What's good? What's good? What's good? You know what I'm saying? But yeah, man, we back with it.
Play Diablo 4.
The time of prophecy has come, knights.
Let's see.
If we can't stop Lilith.
It's 12 juries. Feel me? It's 12 of them. If one of them find them not guilty, bro, then it's a problem. You know, I want to go over saying, I think I want to go I just pay, you know, oh shit. This is why I have hella tabs open. I want to see what that said. It says what? Oh shit. So this is just this live? I gotta change the title. Got Young Thug, man. Hold on, I'm about to go into that. But what I wanna show, you know, and these goes for Young Thug too. You feel me? I should. What day is Young Thug shit? Is this day one?
Ladies and gentlemen, your loss.
I don't know if day one. Or not. So hold on, we're going on.
I'm Cheryl Mercedes. Major developments today in the Boosie murder for hire trial.
Definitely a big day. Both sides put a wrap on it, and so it will soon be up to the jury. Boosie, his real name, Torrance Hatch, is accused of paying Michael Louding to kill Terry Boyd back in 2009. WAP's Tiana Williams is live downtown, just outside District Court, where you've been all week, Tiana. Prosecutors called nearly 24 witnesses or more. The defense called none.
Yeah, that's right, Andre. It was 2:44 when the prosecution rested, and then 10 minutes later, the defense also rested. They called a total of 27 witnesses. This morning, District Attorney Hiller Moore took to the stand. He testified that he did offer Michael Loudon a deal of less than life for admitting to 6 murders if he told the truth in each of those cases that he had knowledge of. Now, the defense questioned why the district attorney, who was present for some of Loudon's interrogation, did not make sure things were recorded if a 17-year-old was admitting to 6 murders. Moore said looking back, he wished things were recorded, but he says he's trusting what the detectives say happened. Now, Terry Boyd's sister was the last witness called by the prosecution. She has a 5-year-old with Hatch. She told the jury there was no problem between her brother and her child's father that she knew about, although she says they weren't the best of friends, but they were not enemies either. The prosecution says it's no surprise the defense called no witnesses.
Had they presented evidence, it would have strengthened the state's case in the fact that there would have been
hold on.
case in the fact that there would have been extensive cross-examination and possibly rebuttal evidence by the state that would have gone ahead and demolished what they could have put on.
Now, joining me now, we have Martin Regan. He is one of the defense attorneys for Torrance Hatch. Now, your I get an opinion of the prosecution saying that why you all did not put on any witnesses.
You know, it was amazing. We were shocked. They had 40 witnesses listed, and having heard their first 27, decided not to call the last 13. And after their very last witness, the sister of the deceased said that there was no beef between Torrance Hatch and her brother. That just sealed the case at this point for the defense. What I heard today, and what we examined very carefully, was a strange number of witnesses who failed to prove beyond a reasonable doubt that Torrance Hatch was responsible in any way for the death of Mr. Boyd. It was amazing that they stopped when they did. And we carefully examined everything that they presented, particularly the last witness at this point, and the fact that 2 police officers, detectives, were caught on video lying at this point to this young man, Mr. Louding. We were convinced that they had not proven their case beyond a reasonable doubt. I think the jury is going to enforce the law vigorously at this point and find our client not guilty.
All right, and tomorrow morning, starting at 9:30, we will hear your closing arguments as well as the prosecution's closing arguments. Following that, the jury will get the case, and they will decide whether Torrance Hatch is guilty or not guilty of first-degree murder. For now, we will send things back to you, Andre and Cheryl, in the studio.
All right, Tina, thanks for your coverage.
No, saying this is when they found him not guilty.
This is 9 News at 6.
He's crying, and he knows from the beginning he was never guilty.
Little Boosie's mother reacts to the verdict. The Baton Rouge rapper found not guilty. Thank you for joining us. I'm Donna Britt.
And I'm George Sells. It is the verdict heard round the world. Boosie is cleared in the murder of Terry Boyd.
It took jurors only an hour to come to their decision. Tiana Williams is live near District Court, where the verdict was welcomed with cheers by some outside there. Tiana?
That's right, Donna. While in the courtroom when that not guilty verdict was read, you could see Torrance Hatch put his fist up in the air, and the judge said, "Son, if that was me, I would have mine up there as well, too." The defense lawyers in this case told the jurors shortly before they made that decision, this case is not about Boosie, but who's being tried first is not the man that is being charged with the 6 murders in this case. Of course, we know the prosecution put on their case, but in this case, the defense was just a little bit stronger for those jurors.
If it don't fit, you must acquit. God is good. I feel good. God is good. I told y'all from jump he's innocent.
A celebration among Boosie fans outside District Court as news of the not guilty verdict quickly spread. The rapper's defense team says it's a verdict they expected.
I expected a not guilty. The first time we looked at the police reports and the documentation, we knew this man should be found not guilty, and we did everything in our power with God's help to prove it.
If you find someone not guilty when the evidence doesn't support it, you enforce the law. These folks enforce the law in finding them not guilty, and we thank them.
He was saying, "Thank you, Lord."
A jury of 9 women and 3 men made the decision. 9 of the...
So, if we count 2, 8, 9, 10, and 12, supposed to be 12 jurors. So, it says right here, 2 black men, 6 black women, 1 white man, and 3 white. You know what I'm saying? Now, you know the blacks, bro. You know they was already fans of Boosie. Let's be real. Let's be real. So, what I'm saying right now is people know who YNW Melly is. If you from Florida, you know who he is. He did a song with fucking Kanye. Come on, bro. Let's be real. Now I'm gonna take it either a little even farther than what it is, right? The dude Danny Polo came up on the stage. He had a ski mask on, ski mask on, right? One of the jurors got a little nervous, a little intimidated because he had his mask on. She came up, and the way how she sound like she's, she's young. She don't sound like no older person. So like, you know what I'm saying? It's all, you gotta take everything in, man. You gotta take everything in. But the countdown is going. We're gonna say, feel me again, if you found guilty, hey man, it is what it is. And if you found not guilty, then hey man, it is what it is. We're gonna say, bro. We're gonna say. We're gonna see what other people say, but I'm gonna go back to that Young Thug case shit.
You keep it the best. Keep it.
Cause I think it's gonna start, or it's already started. So.
With 5 million
2 rappers.
Welcome back to Hot Topics TV, y'all. Just let's get right into the topic. No long introduction or nothing. So the YNW Melly trial. This is what we came to talk about, right? The YNW Melly trial is now essentially over. The jury has gone out to deliberate. The jury is sequestered, meaning they're locked away. They won't have any contact with the outside world. They won't be allowed to discuss this, what they have seen and heard in court from the prosecution and the defense with anybody except for themselves. They're about to get it in and come up with a verdict. All right. At this point, I'm still sticking to what I said before. YNW Melly is going to be found guilty. Did y'all see that closing argument? Did y'all see the closing argument? You know, when YNW Melly's lawyer got up there and started doing all that blundering, I thought to myself, I actually said it out loud. I said, damn, if I was YNW Melly at this point right here is where I would throw myself on the ground, create a distraction so that they would have to pause everything and then reset and come back and get the black dude who did all the work in the beginning, get him to do my closing argument, because that closing argument that his lawyer did,
they should have had the black bro.
They about to send him to
That's
prison.
one thing I was about to say too.
His attorney's behavior was nothing favorable to a jury. You know, he was brash. He was at points disrespectful. When he mentioned a midget and a Jolly Green Giant or something like that, then he was like, he kept on saying a part of a story and he forgot the names. He put a wrong name in it. I can do that. You can't do that. You are an attorney that's standing in a courtroom trying to save somebody from the death penalty, right?
They should have had that black dude. I would have got him. I would have got the black dude up.
Then he goes and picks up the paper. I think his team corrected him. And he picks up the paper and he comes back. He goes, I'm forgetful. I can't even remember. If it's up to me, I wouldn't even be able to remember my own name or something like that. That's not good. That's not something to say about yourself. Actual evidence to paint a clear picture, not when the prosecution rather is. Well, the jury has a lot to look at. Because if I remember correctly, the prosecution called 11 experts and witnesses. 11. Between you getting, you not stop.
Yeah, I would have had the black dude to go up. Instead of him, I would have had the white dude. The black dude. Even though, you know what I'm saying, you could say it don't look good for Melly, but you just, you might have that just one person that be like, bro, I don't find him not guilty. I find him not guilty. You just need that one. So we gonna say, man, we definitely gonna say stuff people gotta understand too is we don't know who they are. We don't know. Melly is a known person. He's not no regular smuggler dude. You feel me? He's not Pookie from down the street. You feel me? He's a known person. So you don't think them jurors already know who he was before he, you know what I'm saying? You don't think they already know? Now, if it got some white jurors in there, they probably don't know who he is. But if they got some jurors who's hit and know who he is, and that shit gonna be whatchamacallit, but we gonna see, man. We definitely gonna see. So I'm gonna go into the Young Thug. Gonna watch this. Matter of fact, gonna see what he says about it real quick. Since
My name is Alfonso, and I got Botox Cosmetic for the first time. The lines that I was concerned the most about were
anti-Melly, whatever it may be. And I think it's interesting because throughout the case, I mean, I say this in every case, when we break down a motion, I always say, whoever wrote this motion, whichever side wrote the motion, whichever lawyer wrote the motion, we should be like, yeah, that makes sense. That's a good argument, because that's what lawyers do, right? They make arguments that are plausible, that have case law, that have evidence, that have testimony, that back up what they're saying, or they shouldn't make that argument. It could be unethical to make an argument if you have no factual basis or good faith basis to make that argument. So you should always have a good reason to make an argument if you are a lawyer. So closing arguments are not different. And I actually really, really enjoyed both sides' closing arguments. I also think that because of the way they have the jury set up in this, that they're sequestered while they're trying to reach their verdict. I think there's a good chance we have a verdict by the end of the day today. At the very latest, I would think Monday, but I really think there's a good chance that we get a verdict today. I will give you my opinion on where I stand verdict-wise, how the discussion would go if I was on this jury. I want the same from you, of course. I'm on my own in this live, so we're not going to do any polls or anything like that. But data, surveillance data, cell phone data, all stacked on top, clearly is trying to point the finger at and show that that Cortland Henry was in fact the person that committed these crimes. But he says, I'm not going to leave Bort with Tao after what you so stuck on me being with, but he's you think that's all I think about? This and saved my life. He's coming everywhere with me, because if them crackers come grab him, it's my fault. You forgot? You don't F with me anyway. I peep it, you can slide, but God no, I wasn't in her SN, Will Reed, real dumb, breaking yo, whatever, you're spoiled. But here's the point. I keep Bortland with, because at the end of the day, he did one of the realest S in my life. So that with context,
Tom said first, and that's what they're talking about.
Sorry. Let me turn this down.
Oh, I thought it was the shit.
With the smiley face. Motives. Anger.
FBI and law enforcement.
But we don't know what the realest shit he's, you know what I'm saying? People want to just be like, boom, you know what I'm saying? But him saying, yo, man, I'm going to keep Boylan by my side because he did the run of the realest shit ever. He could have did, you feel me? He could have did anything. You know what I'm saying? But I get it. I get what people saying, but if you going to look at everything, look at everything. That's what I'm saying. Don't just be one-sided about something. You know what I'm saying? Do it look like he's guilty on this shit? I ain't gonna lie though, the message do look crazy, but to me it's not that so much to be like, oh my God, he's so guilty. Because context out of message, bro, I don't like texting. I like talking to people. Like, because somebody could sit there and say, yo man, anybody can say I love you in the text. Anybody. Do that mean they really love you? Because they said it in the text? You know what I'm saying? Somebody can paint a picture and really think they only for you, they fuck with you and all that in the text. Do that really means they fuck with you and love you in the text? So that's what I go by things. Like they had, you know, him arguing with somebody, arguing with Sack Chaser. maybe that wasn't as people think, because people, you know what I'm saying, people already gonna find you got three people in this type of case. You got the people who are fans, you got the people who already found him guilty, and then you got people in the between. You know what I'm saying? Do I like Melly music? Yeah, I listen to Melly music. Do I listen to it all the time? No. You know what I'm saying? I'm in between. You feel me? One thing I don't want to see is a young black brother to go down. That's something that I don't want to see. They didn't find Zimmerman guilty of what he did. They didn't. We're gonna talk real life facts. They didn't find that motherfucker guilty. And the proof was right there. The proof was in the pudding. So, man, real shit. All this lawyer shit, all this law shit, bro. Come on, let's be real. This shit's sketchy. It's all sketchy. It's all sketchy. It's all sketchy. They're all sketchy. So so this shit gonna start jury debate since 8:30. Oh shit. AM. Yeah, I probably gonna be at work, to be honest. But I'm gonna keep up with the shit, so you already know how that's gonna go. Damn. I'm thinking this shit gonna be let me look this on and see what's up. The jury buzz once they call it. Court will 5 minutes. Jury continue to debate until then. Or she just damn, she don't know. Jury hadn't wait. We were told yesterday 25 minutes to revive. Today, one of the clerks said they have 30 minutes. They are nearby. So I expect to be sooner. I guess. Huh.
And you learned that Adrian Davis showed up.
I would definitely have the black dude to talk though.
As a state attorney, she responded to. Not letting me show this. Oh, sorry.
Play Diablo 4 on Xbox.
I would have the black dude to talk. I would have been like, bro, you go up. But again, I'm in the middle. You feel me? Alright. So alright, we're gonna go to Yellow on Crime. Young Thug shit. Video. How do I get let's go to home. There it is. Young Thug. I got motherfucker.
How Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using irrelevant information.
Same person. Thug is on another different. Hold on. Another.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different.
You know what would be crazy?
Trial on the merits.
If Melly gets out, if Thug gets out, they need to do a collab tape. Break the fucking.
It's the charging document, but I understand, Mr. Steele, that it's different. The state has the burden. Bond is different than proof at trial. I understand that.
So they don't have no jury?
Any further objections, sir?
Somebody said no jury, no trial.
401 and 402 is relevant. I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge.
The defendant, as far back as the time.
Ain't nobody gonna say she thick.
Mr. Greer, who was before the court earlier this year.
I can't stand her.
Initially set
Oh, we got another one.
Trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, "Snitch hoes get murked, them and their kids."
Is this Mr. Williams you're referring to?
It is.
No. I did not get that. Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video.
What the fuck is this dude doing over here?
It proclaims, so people lie to their mama, lie to their sister, lie to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL. Those were his words. Judge, the intimidation factor and the risk of committing.
Oh shit. So we on 2 drones right now, man. Shit. Oh, this is interesting. On 2 of them, finally. Oh, nope. To the wire house?
A similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party.
Yahtzee here. When you need parts, eBay Motors ensures a guaranteed fit. Hey, Dave?
Yep. Wait.
How are those new wipers?
They're small.
Just go to eBay Motors where the check means a guaranteed fit. Let's ride.
Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that the state alleges that Mr. Donovan Thomas was killed as a result of conflict with opposition members, and that the vehicle, we do and can state that witnesses state that the vehicle that was used was one rented by Mr. Williams. We have proffers from persons who have pled, who have said that Mr. Williams then gave everyone money to get out of town that same night. In 2015 rather, understanding that this particular evidence won't be used at trial, much like hearsay is inadmissible. But in 2015, Mr. Williams is found with guns and drugs inside his home, one of them purchased through a straw purchase. You would think after being arrested for that in 2022, he wouldn't have a cache of drugs inside his kitchen, a whole drug store, in fact, inside his kitchen. But not only does he have that, he has guns that have been modified with switches to make them automatic and other firearms inside his home. The person who is listed on the indictment, Mr. Jamari Holmes, as a victim of murder and for which Rodelius Ryan and Damone Blaylock were convicted, those persons, after the killing, placed on social media something akin to slime over hose. In 2022, after two persons who are friends with this defendant are gunned down and killed, the same day or a day after, a picture is posted with Mr. Chamel drinks by Kelvin Watts. And the picture has a zipper face over it and two black shells underneath. A day or two later, Chamel drinks is gunned down. The defendant is charged with being a leader of YSL. The legislature made a point of carving out a separate and additional statute for one who is the leader. Because though the leader may be the one that associates want to keep the hands clean for, they are the ones with the most influence. Jurors have come in and expressed or have shown themselves to be unwilling to be truthful out of fear. Witnesses are afraid and intimidated.
I don't know about the jurors, but the witnesses, the only ones I can listen to in terms of proffer what you're telling me at this point in time that you've actually interviewed. So
yes,
I'll make that clear.
Thank you.
All right.
Your Honor, even after, again, being arrested and having been found with drugs and guns in his home, the defendant in DeKalb County is stopped and found with drugs and guns. I believe that at a previous bond hearing, prior FTA was referenced by the prosecution. Mr. Steele's assertions regarding the nutritional content of the food that the defendant has chosen to consume while he has been confined does not rise to the level of warranting additional circumstances that merit the defendant's release during trial. We would ask that the court find that based on the actions of the defendant, he presents a risk of committing additional felonies and that he poses a risk of intimidating or threatening witnesses. Your Honor, incidents prior to the ones charged in this indictment involve the defendant's presence at other violent felonies, his participation in them, and witnesses' statements that Thug made me do it. I knew I should have followed my mind and ran with him. Other people who are named in the indictment were charged and later convicted, but the defendant is the one who managed to avoid being accountable or held accountable for those actions.
Ms. Love, can I ask you a couple of clarifications? When did the
snitch hoes get murked?
Snitch hoes get murked, and then they and their kids get.
That was in 2010, at the time of Quintavious Greer's trial.
Okay.
And the incidents where calls were made.
Was that more recently?
Yes, it
when
is.
Was that?
Those were made in 2021.
Any calls or any other things after the commencement of this particular trial? Anything after December of 2022 or into 2023?
As we are still reviewing the calls that we have received, I've not come upon ones from 2023. I can only point with respect to things that have been observed by officers and members of the state's staff, the drug transactions that have occurred.
Do you have interviews with more recently? Some of the things you told me, are those based upon witness interviews that you have indicated that have been held sometime by your office, sometime during 2022?
Yes.
And 2023?
Yes.
Okay. All right. All right, madam, anything else?
Not at this time, Your Honor.
Okay.
Thank you.
All right. Mr. Steele, anything else, sir?
Your Honor, I reject the proffer. I would ask you to order the prosecution to hand to the court and to Mr. Williams' counsel, snitch hoes get murked, then their kids in 2010. That did not happen.
She's an officer of the court,
and so am I.
Okay, and
you should.
I believe the law. Mr. Samuels attempted to, when he was involved in this case, to have me do that, and the law doesn't require me to do that.
Your Honor, if you rely on that, you should know what you're relying on. It does not exist. Calls made in 2021, it's a wiretap that they may be referring to. Mr. Williams is not on a wiretap. I've listened to every call.
Okay, well, I'm going to give that less weight than I would the conversations that Ms. Love has had with recent witnesses in 22 and 23.
Let me give you something out of discovery. Mr. Eppinger's mother said that Jeffrey Williams ruined her son's life, recruited him into this YSL criminal street gang, and led her son down the wrong path. Mr. Eppinger's mother is mentally ill. She's never met Jeffrey Williams, and her son never said that. That is the type of information you are being given today to rely upon. Ask the state for the proof. There's no problem. You'd ask me for the proof, and I'd say, here it is. Your Honor, this conversation that Ms. Love wants to have about the legislature made it different for leaders, she does not cite any provision of law, because it doesn't exist. Bond
It's not really relevant for my bond determination at this point in time in terms of, I mean, it's still, I have to look at the Iowa factors, and that's my principal guiding foundation.
But aren't you concerned at some point, Your Honor, that you're being told misrepresentations? At some point, do you just think...
If that's the case, then there are other remedies for this court to undertake and other bodies that this court can refer those matters to. I have to take your proffers that you tell me as counsel when we all go through a very lengthy lengthy licensure to include a professional ethics MPRE examination given in tandem with our licensure as lawyers. So I think most people take that pretty seriously, because to lie to the tribunal is pretty serious. So if I find that out later on, I'll make the appropriate decision.
And Mr. Williams will still be potentially rotting in jail. The point, the rubber has met the road, Your Honor. I'm telling the court, I'm imploring the court to, if you're relying on that proffer, please ask to see the evidence. Going back, every other term used here is in the indictment. Those are the allegations. The state wants to turn it upside down and say, well, just presume that this happened. Presume now a search that was illegal. Let's presume that as well. The failure to appear, what they didn't tell you was there was no notice given. It was a speeding ticket that got dismissed. That's the failure to appear. Your Honor, you are being given information that is not appropriate. I'm telling the court that Mr. Williams, I would not come before the court for a third time. Mr. Williams can have a bond with whatever conditions the court needs. It will just be the right thing to do under law, under IALA, which is AYALA. I'll answer any of the other questions, but the tour bus, Mr. Williams was, Mr. Love rather, because Mr. Williams and that, Mr. Williams was out of state. He was not charged in Cobb County, and there's a memo from the Cobb County District Attorney, who's now a Superior Court Judge, Honorable then District Attorney Reynolds, saying there's not enough evidence to charge Mr. Williams in any crime involving the tour bus shooting
9807 number.
that involves the gentleman.
Says, can we hear Mr. Kelly testimony?
That's what you're being told us today, that somehow Mr. Williams was involved. And I'm telling you different.
When I look through the
Aye, sir. Thank you.
my notes, am I missing something on Courtney Sutherland?
There were 27 witnesses that testified, no one by that name. I don't know if they're trying to refer to the statement of Portland Henry, if they mean one of the other witnesses. I don't know if to read them. The list of the witnesses that testified, ask who they mean.
Any suggestions from the defense?
Maybe ask what they think Courtney Sutherland testified to, and based on the basis of the testimony, we could probably figure out which witness it was.
I would suggest you respond back that there is no witness by the name of Courtney Sutherland.
So my vote would be, that's what I would do. I agree with you, Counsel. I would just say, please clarify regarding regarding Courtney Sutherland. We have no witness by that name. Is that all right with the state?
Yes, Your Honor.
Defense?
Yes.
And what about the call logs?
So that is on States 63.
States
and
53 or 63?
63, and then it's within subfolders therein. So there's multiple call logs from the 9807.
So state 63, Madam Court Reporter, regarding Mr. Kelly, you indicated that it would take you how long to get Mr. Kelly's testimony ready?
Probably not till tomorrow.
Probably not till tomorrow. And on trivia on glass, you're ready to go on that, correct? Is that right?
Yes, Judge, besides I just need to go through it.
Yeah, you need 15 minutes or so.
Yeah.
All right, so just indicate to the record that the court reporter advised that they take about 15 minutes or so to be ready on Mr. Glass's testimony. Mr. Kelly should have by tomorrow, and regarding Ms. Sutherland, we need clarification. So I'm just going to write that back, let you know what it is.
Under Ayala versus the state, or pursuant to Ayala versus the state, decision by the Supreme Court of Georgia and its progeny going forward, decided February the 5th of 1993, cited at 262 Georgia 704. It's still our seminal case in Georgia in regards to the nature of bond. Of course, a trial court may release a person on bail if the court finds a person, one, poses no significant risk of flight from the jurisdiction of the court or failing to appear in court when required. Two, poses no significant threat or danger to any person, to the community, or property in the community. Three, poses no significant risk of committing any felony pending trial. And four, poses no significant risk of intimidating witnesses or otherwise obstruction the administration of justice. And that's OCGA 17-6-1 Echo. Requires the trial court to explain its reasons for the grant and denial of bond to assist in appellate review. That's Lane at 247 Georgia 389. The granting or denial of bail will not be set aside unless there's a manifest and flagrant abuse of discretion. And that's a very old case, Jernigan versus the state, 118 Georgia, 307, pinpoint 308, 1903. Ayala requires, and we all know this, and this has been stated in earlier hearings, that the defendant has the burden of coming forward initially with evidence to show that he or she poses, no significant risk of fleeing, threatening the community, committing another crime, or intimidating a witness. This burden of production means that the person charged with murder must present evidence in the bond hearing of the factors that indicate roots in the community, which Mr. Williams has done on prior occasions. These factors include the defendant's length and character of the residence in the community, employment status and history, past history of responding to legal process, and prior criminal record. Court cites Lane 247 Georgia at 388. Once the defendant meets the burden of production, the estate may present evidence to rebut it, and then the court goes on to say that this is proper to place a burden of production on the defendant. So at that point in time, once that occurs, to protect the presumption of innocence, Ayala goes on to say the state has the burden of persuasion in convincing the Superior Court that the defendant is not entitled to pretrial release. This requirement means the state has the burden of proving by preponderance of the evidence that the trial court should deny bail either to secure the defendant's appearance in court or to protect the community. Depending on the quality of the defendant's evidence, the state may not need to present any evidence to carry its burden of persuasion.
Michael Kelly testimony needs to be
so I have determined in this case that Mr. Williams has in fact met the preliminary standards to show that he has ties to the community and roots in the community. And I find that his employment status and history are sufficient. The thing that still troubles the court has been presented to the state by the state in this particular continuing proffer is that one of the factors I'm supposed to consider is whether or not Mr. Williams poses significant risk of intimidation or threatening of witnesses in particular. The state's proffer of recent conversations and interviews with witnesses in this case, attributing conduct to Mr. Williams, asking for permission to harm others, the court finds that that would make him and pose a significant risk to the community. For that reason, I'm going to deny bond, continue to deny bond at this time. That's my ruling. Okay. All right, Mr. Weinstein?
Your Honor, as is customary in my role, could we take a brief comfort break at this time?
Yes, we can, sir. All right, we'll be in recess. Mr. Steele, just so you may release yourself at any point in time to Judge Ingram, okay?
Thank you.
All right, thank you, sir. We'll be in recess 10 minutes.
Want some candy? I guess I'm super I guess. You sure?
That day I needed money.
I guess
It was Mr. Good back then.
That's my fault. See, look.
Oh my.
I got some cigar bars in here. And I got some.
Oh, look at you.
You want some?
No, I'm really good.
I thought about you. I'm like, you can have some snack today. So, you want some snack on? I'm good right now. Okay. I'm going in.
That's right.
Look, that's no problem with me today, because I think that we have to still attack these 2 pages right here. This is a good problem and all. So I'm good with this. Yeah, I ain't no problem with this. As long as we got dates on here, that's all. I ain't seen him in a while. I see him. He's not.
There are no robots.
And there's always a real person on the phone. I'm not put on hold, I'm not waiting.
They take care of your problem, and you get back to living your life and doing the things that you want to do.
1-800-CONTACTS.
And two other ladies trying to come here also. Mother's lady's mother. He's in a age.
You're always in the middle of the action.
How many guys on who we sit on court? I'll make sure. Check your camera. Check your camera.
Thank you. Thank you. See
It's okay.
Oh, Sarah.
I'm scared.
Every chair on here is all this chair. This is the first chair. This chair is actually three. First is wall. No, the good air in this case, you can hear so play that they are there are Jesus no, it's just this is your you know, the mill out in the referendum. When you get a look at H referendum.
Where from Virginia? Yeah, I went to Virginia. What? To Harvard.
Remain seated, court on the order.
Thank you. All right, Mr. Weinstein, you ready, sir?
Yes, Your Honor.
Okay, hold on. Let me see colleagues from the state. All right, Mr. Weinstein, go right ahead, sir, on behalf of Mr. Kendrick.
Thank you, Your Honor. Good morning, everyone. Are we still morning?
Yes, it is.
Good morning, everyone. On behalf of Mr. Kendrick, I am here to ask you to reconsider your denial of bail. And I'm not an eloquent man, so let me borrow some words to
I think
begin.
you're selling yourself short, sir.
Let me borrow some words to begin with, Your Honor. The shortcuts we take with those whom we believe to be guilty injure only the wrongfully accused and ultimately ourselves. That's what Thurgood Marshall said in his dissent in U.S. v. Salerno. Mr. Kendrick has been in the Fulton County Jail for 438 days as of today. He has not been convicted of anything, Your Honor, as you know. I'm not going to go over what you've already heard in the past. There's no need to rehash that. I just want to bring up a few things that are new since that time. I also want to emphasize something that you said, Your Honor, when you were citing Ayala, which was the word significant before each of those 4 factors. Significant risks of fleeing, etc. And if you would, I would like you to continue to focus on that word significant. Mr. Kendrick is not a significant risk to flee. He has ties to this community. You've heard about them, but let me add some things since we've last spoken to you. Mr. Kendrick's mother, which you can see here, she's up on the 8th floor in 8H. She works nights, most nights. And despite that, she has been here almost every single day of court. You can check the logs. She's here. She is going to be with Mr. Kendrick when he bonds out. They're going to live together. And he has significant support in the community. Mr. Kendrick's daughter, Dawson Greer, is here. She's 8 years old, about to enter the 3rd grade. He has spent a substantial portion of his teenage and adult years right here in Georgia. As you've heard before, he's a graduate of Grady, where he was a football star. And I just want to mention the ties to the community in the football that we heard from DeMarco Dixon. He's with Georgia Trackhawks. And I don't believe the court has heard, but Mr. Kendrick has volunteered his time and money, but time, I think, more importantly, with the Trackhawks to coach 5- and 6-year-old kids in 2021 and 2022. And those kids are asking, where's Coach Yak? And I would like, at some point, for Coach Yak to be able to go back to them. He also has been involved in community fundraising. He was involved with Level 10 and Friends in 2021. So he has significant ties to the community that we may not have raised with you in the past. I believe the court could put sufficient criteria on his bonds, sufficient conditions, or he would not be a significant danger to the community, a significant risk of committing a felony, or a significant risk of intimidating witnesses. He would live with his mother. You can put him on an ankle monitor. He would be under house arrest. And he would stay at home and do what he's been doing here every day in court, which is sitting there writing lyrics and doing his art. Mr. Kendrick, as I said, is in pretrial detention in the Fulton County Jail, which in itself is punishment. The Department of Justice, as you know, has begun an investigation of that jail. They have said incarceration should never include exposure to unconstitutional living conditions, including the risk of serious harm from violence. During his time in jail, and again, I'm only bringing up things since we last argued to you, Mr. Kendrick has been assaulted by a fast officer. He has been pepper sprayed. He has been shot with some type of a pepper gun. He has had his head slammed into a wall at the jail. He's been kicked by officers. Those are incidents that happened to Mr. Kendrick at that jail, a man presumed to be innocent. And they were not committed by fellow inmates. They were committed by people that are supposed to be protecting Mr. Kendrick. That same Justice Department said there are credible allegations that incarcerated persons have died covered in filth and insects. I think we've all seen some of those photographs. The jail is structurally unsafe. People are tunneling through walls. There's prevalent violence and excessive force. I do not believe that that is an appropriate place to keep someone in pretrial detention who has not been convicted of anything. We use those nice sanitized words, like pretrial detention. He is in jail, and he has not been convicted. And there are measures that this court can put into place to ensure the safety of the community as well as the safety of Mr. Kendrick. Your Honor, let me just finish by saying, again, I'm going to resort to U.S. v. Salerno and Justice Marshall's dissent. The shortcuts that we take with those whom we believe to be guilty injure only those wrongfully accused and ultimately ourselves. Thank you, Your Honor.
You're welcome. Thank you, Mr. Weinstein. All right, State. All right, Ms. Hilton.
Thank you, Your Honor. Good morning, Your Honor.
Morning, ma'am.
I want to start with something that Mr. Weinstein said, and he kept on speaking of what he wanted the court to focus on, which is the significant risk of fleeing. And as it relates to Mr. Kendrick, Your Honor, it is the state's position that Mr. Kendrick is a significant risk to flee. Your Honor, in each of the cases that we have within this indictment, from 2015 until the last case that we have involving Mr. Kendrick, which is on May 9th of 2022, this defendant has run from law enforcement officers upon being apprehended in this case. And the state would believe that if released on bond, Mr. Kendrick would flee this jurisdiction. Given what he is being charged with in this indictment, Mr. Kendrick is being charged with murder as well as conspiracy to violate the RICO count, Your Honor. Charges that poses, if convicted, significant and lengthy time in prison. Given that he has a history of fleeing from officers, the state believes, if convicted, he would flee. Next, Your Honor, Mr. Weinstein spoke about who Mr. Kendrick could stay with if he was released. And he identified Mr. Kendrick's mother. Well, Your Honor, the state would have some concern with Mr. Kendrick staying with his mother when it is alleged that his mother brought contraband into this courtroom through clothing and gave it to Mr. Kendrick. So we do not have any confidence that his mother would be the place in which he would stay, given that she brought drugs, allegedly, into this courtroom and provided it to her son.
Objection, Your Honor. There was no allegation that there were drugs in what was brought into this courtroom.
Contraband, tobacco. Contraband, excuse me.
Okay.
Next, Your Honor, while Mr. Kendrick has been in custody, what Mr. Weinstein did not discuss was the fact that Mr. Kendrick has been found with additional contraband, to include an Apple iPhone and an Apple iPod, which he's not to have inside of the jail. And that was on April 5th, 2013. Additionally, Your Honor, on April 26, 2013, Mr. Kendrick is alleged to, while in jail, beat up an inmate by covering that inmate's head, and him, along with 3 other inmates, brutally beat a young man while he was in custody, incarcerated. Given those incidents, Your Honor, we do not believe that Mr. Kendrick, we believe that he would commit felonies while out on bond, if released on bond, given that he's committing them while in custody. Your Honor, last, and certainly not least, in December of 2022, we have incidents of Mr. Kendrick failing to adhere to instructions given by the sheriff's deputies in the jail for which he's being housed. He continuously fails to listen to law enforcement, continuously fails to abide by any instructions, Your Honor, and therefore is not a good candidate for bond at all. Your Honor, bond is for pretrial release, We are currently 7 months into this trial. We are giving these defendants a trial. And at this time, we do not believe that Mr. Kendrick is a good candidate for bond, and we would ask that you deny his bond. Thank you.
Okay. Mr. Weinstein, anything further, sir?
Yes, Your Honor.
All right.
Your Honor, as to the significant risk of Mr. Kendrick fleeing, one of the factors that you look at is his past behavior with respect to following bond conditions, returning to court, etc. Mr. Kendrick has always returned to court. He was on federal bond a couple of years ago. He followed all the conditions of that bond. There's no allegations that he did not follow those conditions. As far as the iPhone, iPod allegedly found on Mr. Kendrick denies those allegations. That was in a common area of the jail and areas that other people would also frequent. As far as the alleged fight in the jail, Mr. Kendrick was protecting himself. Anyone that sees what goes on in that jail knows that it is not a fit place to live, and sometimes you have to protect yourself in order to not suffer harm. 12 of 22, Mr. Kendrick, 12 of 2022, that incident, Mr. Kendrick was suffering from dental conditions. He was trying to get attention. Instead of helping Mr. Kendrick, and look at the medical conditions in that place, look at the turnover of the folks that run the medical facilities. Anyway, instead of giving him attention, he was pepper sprayed. So again, there is no significant risk, once the court puts proper conditions on here, that Mr. Kendrick would flee, Your Honor.
All right, thank you, sir. All right. Applying Ayala versus the state similarly as to the court cited earlier this morning involving state versus Jeffrey Williams and the issue of bond. Similarly, for Mr. Kendrick, the same standard would apply in terms of pretrial release. Trial court may release a person on bail if the court finds the person, one, poses no significant risk of fleeing the jurisdiction of the court or failing to appear when required. Two, poses no significant threat or danger to any person, the community, or property in the community. Three, poses no significant risk of committing any felony pending trial. And four, poses no significant risk of intimidating witnesses or otherwise obstruction or administration of justice. Of course, that I take for the purposes of the bond hearing that the defendant has the burden of coming forward. Initially, the evidence show he, or in this case, poses no significant risk of flight, threatening the community, committing another crime, or intimidation of witnesses. The burden of production means a person charged with murder must present evidence of the bond hearing on factors that indicate roots in the community. Mr. Weinstein's proffer as to Mr. Kendrick is sufficient for those circumstances. Also, his residence, as proffered by Mr. Weinstein, and what he would do upon release, as well as a past history responding to legal process. In this particular circumstance, turning once the defendant meeting the burden of production, the state may present evidence to rebut it. And of course, the state has the burden of proving by preponderance of the evidence the trial court should deny bail, either secure the defendant's appearance in court or to protect the community. And depending upon the defendant's evidence, the state may not need to present any evidence to carry its burden of persuasion. In this particular circumstance, the state has proffered that, in particular, that if the defendant were released, he would flee. They've also proffered that he posed the risk of committing additional felonies, and it is heard from the court that that he poses a significant threat or danger to persons or to the community. I find in that the state, in proffering several things, that, and I was in fact, the court has knowledge of his mother attempting to bring contraband through into this particular courtroom to Mr. Kendrick, and also I also find that the state's proffer is as to his possession of additional contraband, an iPhone, iPad, and the events on 5 April 23, 26 April 23, where he was involved in a altercation with another inmate, as well as the December incident, are indications that he poses a threat to dangerous to person and the community. And for those reasons, I do believe the state has met its burden. I'm going to deny bond at this point in time. All right. Okay, Ms. Von Kaus, any flash drive updates? Ms. Von Kaus, can you give me 1 second? And folks, I'm going to pause just 1 second. I need to check with court administration about a matter. So just give me a second. Yeah, Rule 22, so we have a place for you. There's not enough space.
Hi guys, today I'm sharing TrueConnect, a cellular service. They are on a mission to connect the underconnected. They want to make sure that everyone has a cellular service. As a mom of 4, I know how important it is for me to communicate with my family, and that was even emphasized this year with virtual learning. Yes, virtual learning. Tons of communication. I needed a phone. I needed internet access. Many of us need this information. We all need this information, especially in times of need. Right now, they have a Lifeline service where you can get the cellular service, you can get wireless, you can get hotspot, even the phone activation and shipping for free. It only takes 5 minutes to sign up. Click the link in my bio, check them out by clicking the link in my caption, and make sure you share this post to everyone because it's important that we all have the ability to communicate in times of need.
MC, the court come to order.
Huh? Oh. Is everybody back now?
Yes, sir.
Okay.
Your Honor, I have a small request. We each other 2 minutes on behalf of Mr. Dorsey. Before we move too far away from what just happened, I believe the state made some statements that they have interviews as recent as from this year. We received discovery yesterday. I received draft number 12. Thank you. I'm copying it. I copied it for most of the defense attorneys. I'm almost done with the other two. We would just respectfully requesting if the court could give us the state a date certain to turn over those new interviews, whether they were recorded audio, video, or memorialized in writing. We are requesting for that to be turned over to discovery sooner rather than later, because we are very close to starting.
All right. Ladies, when do you think that will be turned over?
Your Honor, there were interviews and notes that we as attorneys have made that we do not.
Not your notes, not your
Yeah.
notes, not any work product or things that would be considered work product, but any of the interviews themselves.
Right, we don't have any additional interviews recordings of interviews to turn over in discovery that I can think of. But we do have.
Do you have any interviews like recorded or otherwise, or have been transcribed?
We've given the defendants those interviews, and we've given the transcripts of the interviews.
All right.
Your Honor, if I may, if there are, and I don't know if I'm aware of this, there are in fact interviews as referenced by the state previously, whether recorded or not, that reference specific instances of conduct in regards to my client or any of the clients, I would say, we would be entitled to that.
Sure, you would.
And so they made a representation in the previous presentation about people making statements about Jeffrey Williams and things that he has said or other witnesses have said. We are entitled to that, and we're asking the court to order them to turn those matters over to us instantly, immediately, right away.
Okay. All right, ladies.
Your Honor, we have and we will, and anything that we have not yet turned over, I am not aware of, and I will ensure that every memorialization of any interview that is not work product is turned over.
But it might be for multiple purposes, so please make sure that, I mean, you proffered to me certain things, okay?
Correct.
So I hope that you've turned those over already.
We have.
Okay, all right. If there's anything else, like if your team has talked to somebody and you reference any of those conversations, or they exist, I'm just thinking out loud, please, make sure you turn those over like now, if they exist.
Yes, Your Honor.
Okay.
Let me tell the court that we have not received any of those as per the representation made earlier by Madam Prosecutor. We do not have them. As of today's date, as of this moment, we don't have those things that she referred to. So if they contend that they'll turn them over, that is not accurate. And if they can point us to where they'll turn them over and where they are in the discovery, I'm happy to be corrected, but I can tell you now that that's not the case.
Okay, where are they in discovery?
Your Honor, I will get with Mr. Adams, Mr. Steele, or any other attorney and go through the discovery with them and tell them and show them what recorded interviews and transcripts we refer to as far as conversations that I've had with witnesses. Again, I have no recordings of the conversations with the witnesses. Those witnesses' names are on a list and they are listed as witnesses, but I have not recorded conversations with any of those people. I don't record my conversations.
If you had them and they gave information that might be considered to be Brady or exculpatory, you got to turn that over.
That is correct.
So, and I mean, just in the abundance of caution, you got about 8 people's interests in this case. I'd be very cautious about, I turn over everything because you don't know which is going to be exculpatory to whom. So I would tell you, just as a matter of practice, if that's the case, then I'd make sure that is not going to be a problem. Because you proffered stuff to me, and then, of course, I am sure that the attorneys in this case, if it comes up later, or there's going to be a problem. So, if you have anything, please turn it over.
Yes, Your Honor.
Okay, or if anything that could be considered to be either impeachment or exculpatory or whatever, please go ahead and turn it over as soon as you can. Okay.
Yes, Your Honor.
Okay. And also, file a motion, okay, so I can hear it, please. All of you seem to just, I'll listen to whatever you have, but in order to memorialize it, please file a motion so that I can go ahead and make sure that the state responds to it in writing. And if you have some other specific concerns, Mr. Jimenez or Mr. Adams, I would invite you to do that, just so I can preserve it for purposes of the record or for further review, okay? All right, okay. Ms. Von Kelsch, Madam, I believe that you indicated before we took just a break just a second ago that you had some information as it regards to juror 1729.
Yes, Your Honor.
Do you have that documentation? I mean, I have it on, I know you sent it to me, but is there a printed copy of that?
In my office, Your Honor. I
Okay, all right.
apologize. I didn't bring it down.
All right, I'll let you, if you could provide that to Ms. Weaver so we can include it in the record, that would be wonderful. And it can be done today or just at some other time of your choosing, but I'm going to go ahead and reference it for the purposes of the record. Counsels, it appears that juror 1729. I should keep my glasses on. I'd probably have better success. All right. All right. 1729, I apologize, counsels. Juror 1729 was first examined, I think, for hardship on the 12th of July. Is that correct, Ms. Von Kelsch?
I actually have that she forfeited by...
She was supposed to come in for hardship on the 12th of July.
That's right, Your Honor.
Okay, and the reason, counsels, that she did not come in on the 12th of July was that she moved to Florida. And she moved to Florida beginning on June the 29th of this year, and attached to Ms. Von Kelch's correspondence in regards to this is a lease, very lengthy lease, one of 56, 56 pages, which covers the term from June the 29th of 2023 to 7/2 of 2024, and it gives a property address in Lucy, Florida, where this particular juror is going to be a tenant. Is there any further examination I need to make of her, or sufficient with this particular documentation? May we exclude her for residency? Okay. All right. So we're going to. So, Ms. Von Kelch, whenever you get a chance, just provide and I'll include that as next, your email and this rather lengthy. Actually, you give me the first 5 pages or thereabout, the relevant 5 pages. And counsels, it is a 56-page lease, but Ms. Von Kelch has given us about the first 4 pages. It gives the rent. It gives the information of the term. It gives the property address, the residence. It gives the lease term and possession and termination and signatory pages. So those are the only things I'm going to include for purposes of the record with your concurrence. Anybody have any objection to the contrary? No. Okay. All right. So that'll be the next court exhibit in order. All right, thank you very much, Ms. Von Kelch. Okay, all right. See if I can print it. I may be able to print it here. Let me resolve that. Okay, I think we've concluded most of our business except for the administeria of continuing with our accounting for groups 6 and 7, which was also our business item for today. And let me just get my notes here. Pardon me, thank you, sorry. No, it's terrible, it's pollen. All right. Let me see.
Okay, I'll just bring it. We're good. Okay, 1721. Are you sure? Yeah, you copied me on the email. Okay, so I'll just bring it. Okay, thank you. One last thing for me.
Christine. There it is. And here you go. And there's the other two motions yeah, please. Okay. All right, councilors, let's see if we can go ahead and get our housekeeping matters dealt with in terms of group 6 and 7. I believe that will conclude our business for today. So, Mr. Randolph, are you ready, sir?
Yes, Your Honor.
All right. Councilors, we're going to start off with beginning of group 6, and that would be 1214 to 1596. So, Mr. Randolph, whenever you're ready, sir.
Yes. 1214, excuse, 5-3. 1215, excuse, 5-3. 1216, excuse, 5-3. 1217, excuse, 5-8. 1218, excuse, 5-3. 1219, excuse, 5-8. 1220, stay, 5-3.
Examined?
Yeah, they were examined.
Sorry.
1221, stay, 5-3.
Examined.
1222, excuse, 5-8. 1223, excuse, 5-8. 1224.
Okay, who's missing? Okay, no, in terms of our accused. Accused.
And Your Honor, I believe that there are searches being conducted outside the courtroom right now.
All right, I'm going to finish taking roll, and then we can kind of see who's here. All right? Mr. Adams and Ms. Calland? Good afternoon, madam. Mr. Blaylock and Mr. Hill? Good afternoon. Mr. Eppinger and Mr. Johnson? All right, good afternoon, sir. Mr. Ryan and Ms. D. Williams? Okay, all right. Okay, Mr. Harvey, I understand he's here. I saw him walk in just now, so I've accounted for him. Where's Mr. Botts and Mr. Jimenez?
Your Honor, when I peeked out the hallway, I saw both of them at the table where the search is.
Okay, all right. So I just give it a minute. Should be coming in now. All right, Mr. Botts is now present as well. Okay. All right, Mr. Chairman is present with us, okay? I believe that accounts for all of our attorneys. All right. Mr. Steele and Ms. Love, can I see you for a second? Okay. Mr. Adams, you're welcome to join up if you'd like.
You got another meeting.
This council, this is state attorneys. The jury's adjournment. We have a new jury inquiry question. It says clarification. Courtney Sutherland should have been Portland Henry. We have decided we do not need to hear his statement from the hospital. Trevion Glass, we would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So my thought is just to bring him in. We'll have him read back Trevion Glass testimony now. I think court invitations ready on that. Is that right?
Your Honor, I'd like to take a few positions with respect to the questions. With permit. With respect to the reading back of the testimony, our position is that testimony is comprised not only of its substance, but the manner in which it's delivered. When we are in a fortunate situation such as this, where the entire testimony is captured on video camera, we think it would be more appropriate for the jury to either be told to rely upon their recollection, because even though their recollection would be incomplete, it would be comprehensive. They'll be recalling not only what was said, but the manner in which the person testified. A gentleman like Trevion Glass in particular, who was hiding behind the monitor for half of his testimony, and then hiding deliberately behind his dreadlocks for the rest of his testimony, I think his testimony is going to look a whole lot better on paper than it did when it was delivered. The best evidence of his testimony was captured on videotape, and the jury would be able to see it. And so we would suggest that since we're in a situation whereby the testimony has been captured on video, that the best practice in this instance would be that any testimony that is asked back for not be read back, because it would be devoid of its context, but be shown. And with respect to Mr. Kelly, Officer Kelly, whose testimony won't be available until tomorrow, it would also expedite matters, because I'm sure it would be a lot quicker to obtain video footage than it would be to have it typed up. My other point would be this. The request for the testimony of Mr. Glass and Kelly both came in the same question. And subsequent to that, we received a note that indicates that there may be factions that are beginning to calcify. We can only speculate as to what the jury is thinking and saying. But I think it's unequivocal that the substance of Mr. Glass's testimony favored the state. It is also unequivocal that Mr. Kelly made some concessions that essentially his analysis had defects and he really couldn't draw the conclusions that he was attempting to draw. So one can surmise that maybe that might be more favorable to the defense. If we have a jury that's now divided into factions and one side is sending for information that might support their argument, another side is sending for information that might support their argument, then I think it would be unfair if we allow one side of that faction to get their ammunition and wait another 24 hours before the other side is able to meet that argument with whatever they're trying to fashion, or whatever that testimony they're using as a component of their position.
So we think it would be prejudicial because we got both requests in the same questionnaire or same question, asking for the testimony of both people. And until both is available, first of all, we'd like it to be shown back as opposed to be read back. And secondly, we think that it should be done at the same time so that both sides, assuming they're for different sides, are equipped with the ammunition they need when they go back and the deliberations continue. But we think it would be extremely prejudicial if Mr. Glass's testimony were to be read today and we tell them, wait until tomorrow before we get your papers.
Thank you. David Spears.
Your Honor, it's entirely speculative. The rules would conform with a readback occurring. The state would suggest that Your Honor should stick to the rules of criminal procedure on this case.
So objecting to having some type of seeing what the crime, whatever the born crime video is, and have that played back to you.
Yes, Your Honor.
Anything else, counsel?
Yeah, well, once we can ascertain that it's complete, then clearly it's the best evidence. There might be rules which do not contemplate the existence of video, but now that we know we have it, the court as the gatekeeper knows that it will not be an inaccurate reflection of what has occurred. As a matter of fact, it will be the best evidence of what occurred. And therefore, to use a procedural deficiency as a basis for objection, I think is an attempt to obfuscate what would be the best evidence and the truth. And I don't think the state took a position with respect to whether or not it should be read at the same time, but we would maintain that it would be prejudicial to Mr. Demons. And I know we're reading tea leaves, but because we don't know what's going on, it's all the more important that we give the jury what they asked for at the same time that they asked for it and not split it up.
Thank you. Well, counsel, respectfully, the court reporter is the person who keeps a record of the proceedings. So if they want to read back, that's what we're going to do. We're going to have to read back. I understand the case was live streamed, but that's not in evidence. The court reporter can read it back. That's what the rules provide for. That's what we'll do. Regarding Mr. Glass and Mr. Kelly, Mr. Glass's read back, my understanding his testimony is relatively short. It didn't take the court reporter too long to do that. She's going to read that back now. She's working on Mr. Kelly, and when that's available, she'll read Mr. Kelly as well. You're objecting to this note, so we'll
thank you, sir.
You bring the jury in? Yes, sir. jurors in the jury room wanted to supplement your positions then?
Yes, please. In lieu of them watching the testimony, which we maintain is the best alternative, to allay some of the concerns we have with respect to prejudice, we would ask that an instruction be given to the jury reminding and admonishing them that a readback do not reflect the matters of demeanor, tone, or voice in which the testimony was given. So we ask that the jury be reminded that a readback is not a complete accounting of the testimony because it doesn't account for manner, tone, voice, and the things which they may have observed. So we ask that that instruction be given prior to them getting the readback or after.
There is a standard jury instruction 4.4 that covers this. That would be the state's position that that's what you're on the screen.
Let me take a peek.
Thank you. That's what I typically would do, ask them to read back the state's jury instruction.
I do notice that that the headings of each one of these speaks to readback / playback. So I do believe the rules do contemplate a playback as opposed to a readback. Just to correct the record, because my understanding from the state was that a playback was not called for, but this proposed rule does actually mention playback.
Thank you.
Your Honor, also, this Rule 4.4 does not contemplate the issues that are concerning, particularly with respect to Mr. Glass hiding behind the monitor and behind his hair. We think that it's important that the jury be reminded that tone, manner, and comportment during testimony are also important in their assessment of credit. So we ask that not just the standard.
Thank you.
Thank you.
Madam State, any additional? Two things, counsel. Number one, my understanding of the readback, playback issue has to do with evidence. It's something that's in evidence that's going to be played back to the jury, not trying to find out something that was live stream, not in evidence to play back to the jury. I think there's a difference. That's the first thing. Second thing, regarding the witness, my recollection was you said he was hiding behind it. My understanding is you asked him, or somebody asked him a question about it, and he said he was blind in one eye. I thought that was the issue, he was blind in his left eye. But regardless, I'm sure it's in the transcript. But your objection, I'm just going to read this thing. All right? Bring the jury in.
Thank you.
Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, assistant attorney. I have a jury inquiry form. It says request to view evidence. It states clarification. Courtney Sutherland should have been quote Henry. We have decided we do not need to hear this statement from the hospital. Then it goes on, Trayvon Glass, we would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So what I've done, ladies and gentlemen, I've talked to the court reporter, and she is able to read back the testimony of Mr. Trayvon Glass at this time. I've discussed this with the attorneys, and the court reporter is going to read that back now. As far as Michael Kelly, she's working on getting that done, and as soon as it's ready, we will have it read back to you, his testimony. So, the court reporter can read back the testimony of Mr. Trayvon Glass, please.
Okay. All right, we're going to take recess for 1, so I'll see you all back at 1:30, and we can kind of update according to that time, okay? But it is the court's intention to probably to go until probably around 3 o'clock.
The court, next witness, please.
Ms. Smith, Trayvon Glass. Just for purpose of the record.
Sure.
The court, are you ready, Mr. Glass? The witness.
Has always
Yes, sir.
apologized.
The court, welcome. This is our witness stand over here. Once you come to the witness stand, what I'd like you to do is remain standing, raise your right hand to be sworn. The clerk, do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth? The witness, I do. The clerk, state your full legal name for the record. The witness, Trayvon Glass. The clerk, please spell your first and last name for the court reporter. The witness, TRAVELONGLASS. The court, please have a seat. Mr. Glass, that microphone in front of you, only just up or down because it moves back and forth. The witness, all right. The court, so if you could scoot up close to the microphone. Ready to proceed, sir? Counsel, you may. Ms. Smith, thank you, Your Honor. Direct examination by Ms. Smith. Question. Good morning, Mr. Glass. Answer. Good morning. Question. I know that you were quite soft-spoken, so I'm going to need you to speak up a little bit, a little louder. Okay, and remember, you have to make oral responses, okay? Answer, yes. Question, how old are you? Answer, I'm 23. Question, and where are you currently living? What city? Answer, Vero Beach. Question, and have you lived there all your life? Answer, majority of it.
These two people.
Question, okay, you completed high school, or what was the last grade you completed? Answer, 11.
Of what occurred at our bench conference.
Question, all right. You're not married, correct?
For those
Answer, excuse me?
And I'll see everybody back around.
Question,
okay?
you're not married?
We're in recess until.
Answer, no. Question. So
Keep It Quilted means you keep it the best. 3 layers of plush comfort you can see and feel. Keep it quilted because the best parts of your life deserve the best. So don't settle for anything less. Keep it quilted with Quilted
To
Northern.
my best knowledge, once. Question. If I were to show you something, would that refresh your recollection? Answer, yeah. Question. A prior judgment? Ms. Smith, Your Honor, permission to approach the witness? The court. First, show counsel first, please. Ms. Smith, yes. Question. I'm going to ask you to just look at the document. Don't say anything, okay? Have you had an opportunity to review the document? You have to answer. Answer yes. Question. All right. Is your memory refreshed as to how many convictions you have? Answer 2. Or is that 1? I don't know shit. I see 2 charges. Question. All right. Now, you currently have some pending charges in Indian River County, correct? Answer, yeah. And those are 2 charges? Answer, yeah. Question. Misdemeanor resisting without violence? Answer, yeah. Question. And an obstruction of service or execution of a search warrant? Answer, yeah. Question. Are those misdemeanors or felonies? Answer, I'm not sure. Question, okay, do you know what the penalty you are facing on those charges? Answer, no. Question, have you been offered probation in that case? Answer, yeah.
And have you been made any promises in exchange for your testimony here today? Answer, no. Question, all right. So let's go back to October 26, 2018. What were you doing like for work? Answer, I wasn't working at all. Question, were you involved in the music business at all? Answer, kind of, sort of. Question, and how so? Answer, making beats. Question, all right, and when you were making beats, were you working with a specific group or music group or people? Answer, one person to be particular, but yeah, it was supposed to be in a group. Question, all right, let's start by saying this. What group was it? Answer, in YNW. Question, all right, and when you said one person specifically, who was that person? Answer, Judy. Question, and can you tell the members of the jury Judy's real name? Answer, Christopher Thomas. Question, and how long had you known Christopher Thomas, who you refer to as Judy? Answer, over a decade. Question, and this is back in October. And did you know somebody by the name of Anthony Williams who went by Sack Chaser? Answer, yeah. Question, and how long have you known Sack Chaser? Answer, a couple of years. Ms. Smith, permission to approach the witness with State 73. The court is in evidence. Ms. Smith, yes. The court, yes, you may proceed. By Ms. Smith. Question, Travion, I'm going to ask you to take a look at State's photograph number 4 in State 73. Do you recognize that person in State's photograph with the label marking 18-3118? Answer, I do. Question, and who is that? Answer, Anthony Williams. Question, so back on October 26, 2018, do you recall being at the New Era studio? Answer, yeah. Question, who were you with? Who were you there with? Answer, a few other people. Question, okay, was Judy and Sack there? Answer, correct. Question, all right, and do you recall around what time you guys got to the studio? Answer, I'm not sure when we arrived. Question, was it light or dark outside? Answer, I believe it was dark, I'm not sure. Question, all right, and what was the intention going to the studio? Answer, I believe we were supposed to have a 12-hour session. Question, all right, and that's a 12-hour recording session, right? Answer, yeah. Question, and who was the artist that was recording that night? Answer, it was everybody. Everybody was an artist in that room. Question, all right, did you guys end up staying for 12 hours? Answer, nah. Question, okay, what changed and why didn't you end up staying? Answer, to the best of my knowledge, people were sleeping, so we ended up going home because you don't sleep in the studio. Question, all right, and part of that is because studio time is paid for. Answer, paid for. Question, okay, you just said it was paid for. What was paid for? Answer, studio time. Question, so you guys had prepaid for 12 hours? Answer, correct. Question, I'll move on. How long? Well, you said that people were sleeping. Who was sleeping? Answer, everybody but me, Anthony, and Christopher. Question, was someone upset that people were sleeping? Answer, I guess you could say that. Question, and who was that person? Answer, Sack. Question, and how did Sack respond? How did Sack respond to people sleeping? Answer, he woke them up and let them know it's time to go. And how did he do that? Answer, yeah, he went and woke them up, shook them up. Question, okay, so at some point you just mentioned that guys were getting ready to leave the studio. Answer, yeah. Ms. Smith, publishing State 72, publishing image number 1 in State 72. Question, Mr. Glass, can you see that photo on the screen in front of you? Answer, yes. Question, okay, and who is that person? Answer, to the best of my knowledge, Melly. Question, okay, and the person I'm referring to, what is he wearing? Answer, a jacket. Question, all right, do you recognize the person on the other side of the photograph wearing what appears to be a black shirt? Answer, kinda, sorta. Question, if you do? Answer, no, I don't. Question, publishing image number 2. Do you recognize individuals in that photograph? Answer, 2 of 3 of them, yeah. Question, okay, so what you can do is identify them by clothing that they are wearing. Answer, Juvie, black jacket to the left, sack in the middle, jean jacket, Tay, black jacket. Question, and sack, is he standing or sitting? Answer, sitting. Question, and Tay, is he standing or sitting? Answer, sitting. Question, and you said Cortland was wearing a black jacket. Is he standing or sitting? Answer, who? Question, how did you refer to him? My apologies. Answer, Tay. Question, no. Answer, Juvie. Question, the person wearing the black jacket, who did you identify that as? Answer, Juvie is wearing a black jacket. Also, it's Tay wearing a black jacket. Question, the person wearing the black jacket who is standing up, do you recognize that individual? Answer, that's Chris. Question, okay, do you recognize the people in photograph image 3? Answer, same one you just showed, same person. Question, and who is that person? Answer, Melly. Question, the 3 images that were just shown from State 72, do you recall when those photographs were taken? Answer, same night. Question, would that be, what date would that be? Answer, 10/26. Question, of 2018? Answer, yeah. Question, what location were those photographs taken in? Answer, New Era Promotions at the studio. Question, was that the studio we just discussed that you guys were hanging out at? Answer, yeah. Ms. Smith, I'm now publishing Stage 7, publishing 10/26/2018, beginning at timestamp 2/17/42. Question, Mr. Glass, do you recognize the 2 individuals on the screen paused at 2/17/47? Answer, do I recognize the back of their head? Answer, yes. Do you recognize them? Answer, I just see the back of heads. Question, okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52? Answer, still the back of the heads. Question, do you see an individual standing next to a red vehicle? Answer, yes, that's Kobe. Question, you just said that's who? Answer, Kobe. Question, and what is Kobe's real name? Answer, that's what I know him by, Kobe. Question, all right, would anything refresh your recollection as to his legal name? Answer, I don't know. Question, if I were to show you your prior statement, would that refresh your recollection? Answer, it could. Ms. Smith, permission to approach the witness? The court, you may. Question, Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. Has your memory been refreshed as to the legal name of Kobe? Answer, yeah. Question, what is Kobe's legal name? Answer, Jacoby Mills. The reporter, I'm sorry, the witness, Jacoby. By Ms. Smith. Question, all right, if you can repeat the last name for the court reporter. Answer, Mills. Question, I'm going to continue to publish Stage 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual? Answer, not really, no. Question, okay, how about the individual that is standing at the gray Jeep? Answer, that's Zach. Question, I'm going to continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep? Answer, I see him. Yeah. Question, do you recognize him? Answer, that's AD. Question, I'm going to ask you for AD's legal name. Answer, I know his last name is Davis. Question, okay. Would looking at your statement refresh your recollection as to his legal name? Answer, I guess so. I don't know. Ms. Smith, Your Honor, permission to approach the court. Is that the same statement? Ms. Smith, yes, Judge. Approaching the witness. Question by Ms. Smith. Mr. Glass, same procedure. If you could take a look at that and look up. Answer, unintelligible. Question, no, without speaking. Has your memory been refreshed as to AD's legal name? Answer, yes. Question, okay, what is AD's legal name? Answer, Adrian Davis. Question, continue to publish state 7. Mr. Glass, let me know if you need to rewind the video. Did you have a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts? Answer, that's me. Question, continuing to publish. I'm pausing the video on 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket? Answer, say that again. Question, do you see the person on the video? Answer, I see the back of his head. Question, do you see the back of the head of the person wearing the jean jacket? Correct. Answer, correct. Question, do you see the jacket in state 72, image number 3, the front of the jacket? Answer, yeah. Question, do you see that jacket in state's image 1 of state 72? Answer, I see the same thing y'all see. Question, we spoke about this, Mr. Glass. Answer, I said that. The court, excuse me. Counsel, you ask questions, all right? By Ms. Smith, question. I'm asking questions, Mr. Glass, and just asking you to respond if you have knowledge. Is this the jacket that was in image number 1 and image number 3, the jacket that Melly was wearing on October 26th of 2018? Answer, to the best of my knowledge. Question, to the best of your knowledge, yes or no? Answer, yes. Ms. Smith, publishing state 7. Question, I'm back to state 7, timestamp 2:18:41. The individual that's on screen wearing the jacket, it appears something across his back. Who is that individual? Mr. Glass, can you respond? Answer, I see the same person as last time. Question, okay, and can you tell us who that same person is? Answer, Melly. Ms. Smith, continuing to publish. The witness asking questions I don't know the answers to. By Ms. Smith, question. Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking you if you see them, just if you see them. Answer, yes. Question, do you recognize that person? Answer, of course. Question, and who is that person? Answer, Christopher Thomas. Question, Mr. Glass, can you identify for the record? I know there's a video, but can you identify which vehicle you got into? Answer, the red Mitsubishi. Question, and can you tell us who was in the car with you? Answer, Kobe, Tay, and AD. Question, so AD, Tay, and Kobe. Answer, Is that a yes? Answer, yes. Question, so that is a total of 4 people. Answer, correct. And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge? Answer, everybody else that was there. Sack, Melly, Juby, and Cortland. Answer, okay. I'm sorry, question, okay, and by my count, is that also 4 people? Answer, correct. Question, and when those continuing to publish at 2:19:36, I'm going to stop at 2:19:46. At the time you left the scene in that red Mitsubishi, where were you headed? Answer, supposed to be home. Question, who's home? Answer, I guess Melly's house. Question, and was everybody in that red car headed to Melly's house? Answer, to the best of my knowledge. Question, and what about the Jeep? Where was your understanding that the Jeep was headed, the gray Jeep? Answer, same spot. Question, so both cars left the studio with the intention of heading to what you identified as Melly's house? Answer, correct. Question, can you tell us, I guess, what was the mood or the vibe of the studio while you guys were there? Answer, it was years ago. I can't tell you nothing right now. Question, okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio? Answer, just like a regular day at the studio, smoking and drinking. And you just mentioned smoking. Where are you smoking? Specifically you. Answer, weed. Question, all right. And now the vehicles. We saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge? I can't tell you because I don't know. Do you recall getting on a highway at all? Answer, I recall being in the car while it was driving. I don't know where. I don't know. I don't. Question, were you awake the entire time you were in that vehicle? Answer, I wasn't. Question, okay, do you know at what point you fell asleep? Answer, I don't. Question, all right. And when you left the studio, you were awake. Is that a fair statement? Answer, I was. Question, and at what point do you recall waking up, or what time do you recall the next thing you saw? Answer, once it came to a stop. Question, all right. And where did you come to a stop? Answer, at the house gate. Question, at the house gate for Melly's house? Answer, yeah. Question, when you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi? Answer, same people you've seen get in the car. Question, by your testimony, Kobe, AD, Tay, and yourself? Answer, yes. Question, okay, so still 4 people. Answer, still 4 people. Question, do you recall how you guys entered the gate? Answer, the gate was open for us. Ms. Smith, publishing states 47. Question by Ms. Smith, I'm going to pause it at timestamp 349, looks like 58. Do you recognize that red Jeep Mitsubishi? Answer, I do. Question, is that the vehicle that you left the studio in? Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes, yes. Question, do you see that screenshot at timestamp 351:31? Answer, Question, is that a yes? Answer, yes.
Back, yo, my bad.
Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right. Did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right. So what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay. And you said upstairs. So the house is how many stories? Answer, a couple. Question, okay. So you went upstairs to where specifically to sleep? Answer, to Judy's room. Question, all right. Was Judy in his room? Answer, no. Question, do you recall where Melly's room was in the house? Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room, and what do you do? Answer, crash. Question, crash meaning, answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony and Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start about with the city. Do you recall what city that house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looked similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at State 62. Do you recognize individuals in State 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frito wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frito's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person. Question, and before you left the hospital, or actually, who went to the hospital with you and Drew? Answer, just Drew. Question, who was at the house, Melly's house, before you left for the hospital? Answer, same people that was there when we got there. Question, okay, same people being the 4 people that entered the Mitsubishi? Answer, yes. Question, so you're at Frida's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were? Answer, Judy's room. Question, no, not Melly's house, Frida's house. Where were you at Frida's house? Answer, outside. Question, okay, and who was at Frida's house when you first got there? Answer, everybody that was in the house. Question, because I don't know who everybody was or is, can you please specify? Answer, Kobe, Melly, more people I don't know. Question, okay. Was that the first time you saw Melly after you guys left the studio? Answer, yeah. Question, was Melly wearing the same clothes or different clothes than when you saw him at the studio? Answer, nah, he wasn't. Question, nah, he wasn't. You got to specify. Answer, he wasn't wearing the same clothes. Answer, okay, do you recall what he was wearing? Answer, just had on some shorts. Question, and how long do you stay at Frida Wayne's house? Answer, I don't know. Question, okay, minutes, hours, days? Answer, could be minutes, could be hours. Question, so not days. Answer, not even a day. Question, so when you got to Frida's house, was it light or dark outside? Answer, light. Question, and you previously said yourself and Melly and someone else was at Frida's house. Was Frida there as well? Answer, I think I did see him, I don't remember. Question, okay, what happens while you're there? Like you're there, you're outside, what happens? Answer, I'm grieving. Question, and you're grieving. Are you grieving alone? Answer, yes. Are you at the house at any point in time? Do more people come to the house or do people leave the house? Answer, if they did come, I don't know. I was in the back there grieving. Question, at any point in time, did Melly leave Frida's house? Answer, it came to a point where I was there by myself. Question, all right, so you were there by yourself. So the people that you previously said were there were no longer there, correct? Answer, correct. Question, and so do you know where they went during that time? Answer, I don't. Question, and we're still talking about October 26th of 2018, correct? Answer, yes. Question, and this would be shortly after the hospital? Answer, yes. Question, at some point does Melly come back to Frida's house? Answer, around that time I'm still grieving, getting a little, I don't know, yeah, I guess. Question, I guess Melly comes back? Answer, yes, I guess they did come back. I don't know, I'm not sure. Question, at some point does Melly leave again a second time? Answer, I don't remember anything from after that. For me grieving, that was the last thing I remember, was me grieving, and I end up in Gifford. Question, so before you end up in Griffin, sick, if I were to show you your statement, would that refresh your recollection as to Melly leaving and coming back a second time? Answer, I suppose so. Ms. Smith, permission to show him statement again? The court, yes, counsel. Question by Ms. Smith. Mr. Glass, I'm going to give you page 5 and page 6. If you could take a look, you can start in the middle and review those pages and look up when you're done. Are you done? Answer, uh-huh. Is that a yes? Answer, yes. Question, did that refresh your recollection? Answer, somewhat. Question, okay, so tell us what you somewhat remember. Answer, I just did. Question, if you recall, you said you weren't sure, you went to Gifford. And then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again? Answer, I'm not sure. I was grieving. I'm not sure what nobody did. I was grieving. Question, let's see. I pointed out to you the person that was wearing the jacket that you identified as Melly was carrying something across his side or his back on the video. Do you recall seeing that? Answer, I guess. Question, do you recall what that's referred to? Answer, a satchel. Did you see that satchel again after you left the studio? Answer, no. Question, do you know what was in the satchel? Answer, I don't. Question, okay. Do you recall seeing anyone else with the satchel that night at the studio? Answer, that was 5 years ago. I don't recall. Question, is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel? Answer, I suppose so. Question, if I were to show you that video again, would that refresh your recollection? Answer, I suppose so. Publishing state 7. Question by Ms. Smith. I'm going to start publishing start 7, state 7 at 2:19:01. I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying a satchel? Answer, yes. Question, who, if anyone, was carrying a satchel? Answer, I see Chris with one. Question, and that's Christopher Thomas? Answer, yes. Question, did you ever have any business relationship with the person referred to as Track? Answer, no. Question, okay, do you know who Track is? Answer, not really. Question, not really, or answer, I don't know who he is at all. Question, do you know of him? Answer, yeah. Question, did you see Track on October 26, 2018 at any point? Answer, no. Question, do you recall giving a statement, specifically the statement that you previously provided, that I previously provided you with here today to the detective in this case? Answer, Question, you have to answer out loud. Answer, yes. Question, that was a statement that you gave to Detective Moretti and another detective, I believe from Indian River. Is that correct? Answer, it could be. Question, would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018? Answer, I don't know. I don't know Track. Question, no. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26th of 2018? Answer, no. Question, one moment. You said you ended up back in Gifford at some point in time on October 26th of 2018. Answer, yes. Question, and do you recall where Melly was at the time you went to Gifford? Answer, I don't remember. Question, at some point at Frito's house, do you guys all leave, meaning you yourself, everybody that you previously identified that was there? Answer, I don't recall. Question, you don't recall leaving? Answer, I don't recall leaving with anyone. I don't know where I left. I don't know how I left. Question, okay, just to clarify my question, so you mentioned you left. When you left with Gifford, was anyone else at Frito's house? Answer, I don't know. Question, do you recall Melly making any statements in your presence while you were at Frito's house? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to anything Melly told you while you were there? Answer, I don't recall. Question, so you remember them leaving the house at least once, correct? Answer, yeah. Yes. Answer, yes. Question, all right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time after the first time? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to those statements? Answer, no, it wouldn't. Question, all right. Do you have a Facebook page back in October 26th of 2018? Answer, I believe so. Ms. Smith, I'm approaching counsel with what's been marked as state's quadruple I, which was previously shown permission to approach the witness. The court, you may. Question by Ms. Smith. Mr. Glass, do you recognize these 2 pages that I'm showing to you? Answer, I guess so. Question, and this is a Facebook, do these statements reflect a Facebook conversation? Answer, they do. Question, is this a fair and accurate representation of the conversation that you had on Facebook? Answer, it is. The clerk states quadruple I will be marked as states 83. Ms. Smith, permission to publish? The court, you may. Question by Ms. Smith. Mr. Glass, can you see that document in front of you? Answer, yes. Question, all right, where it says author, can you read that for the members of the jury? Answer, you want me to read it?
Excuse me one second. Danielle and I keep the message of one of your members needs a restroom break, so we'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in presence. We'll be back in finish reading shortly, as soon as we're done with the restroom break. All right? Thank you. Thank you. Let the record reflect the jury stepped out. Mr. Devins, you need a restroom break?
Yes, sir.
Can we arrange that for Mr. Devins?
Yes, sir.
Thank you. We're in recess. Hopefully, forecast.
Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes, yes. Question, do you see that screenshot at timestamp 3:51:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right, did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right, so what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay, and you said upstairs, so the house is how many stories? Answer, a couple. Question, okay, so you went upstairs to where specifically to sleep? Answer, to Judy's room. Question, all right, was Judy in his room? Answer, no. Question, do you recall where Melly's room was in the house? Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room, and what do you do? Answer, crash. Question, crash meaning? Answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony and Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somewhere, somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start with the city. Do you recall what city that house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looked similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at State 62. Do you recognize individuals in State 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frito wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frito's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person.
Thank you. Please be seated. Let the record reflect the equivalence of the defendant, the counsel, the assistant state attorney, and the ladies and gentlemen jury. When we vote, I think we will start on the readback of Mr. Glass. Madam Court, could you continue with the readback, please?
Question by Ms. Smith. If you can read that, what does it say next to author? Answer, Fargo. Question, what does it say before Fargo? Answer, Fetty Fargo. Question, do you see where it says Fetty Fargo? Answer, I see it. Question, okay. And who's Fetty Fargo? Answer, it was me. Question, who was that? So was that was that how you identified yourself on Facebook? Answer, kinda, sorta. Question, who were you having these conversations with? Answer, right now it looks like I'm talking to myself, like I was texting. I don't know who I sent it to. Question, do you see where it says participants? Answer, okay, so texting Melly. Question, that was page 1. I'm going to now publish to page 2. I'll publish it in part since it's a little small. Can you see that in front of you? Answer, yes. Question, I'm going to scroll up. What was the purpose of you having this conversation with Melly? Janelle Demons. Answer, I don't know. Just everything was questioned. Question, when you got to Gifford, were you looking for answers? Answer, not just me. Question, were people kind of pressing you for answers? Answer, correct. Question, and did they have any impact whether or not you reached out to Melly? Answer, I don't know what you mean by that. Question, so again, you said that people were looking for answers. So did you reach out to Melly looking for answers? Answer, I did. Question, is that the gist of that conversation on Facebook? Answer, is that just? Question, meaning the gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him? Answer, yes. Question, do you know who Jamie King is? Answer, I don't know who she is. I know of her. Question, do you know her relationship? Answer, his mom. Question, do you know the relationship between Jamie King and Anthony Williams? Answer, I don't. Question, if I were to show you a copy of your statement, would that refresh your recollection? Answer, nope. Question. Sorry, Ms. Smith, and 1 moment to confer. Nothing further at this time. The court, counsel, thank you. Any cross-examination of this witness? Mr. Howard, yes, sir. Good morning, ladies and gentlemen. The jurors, good morning. Cross-examination by Mr. Howard. Question. Good morning, Mr. Glass. Mr. Howard, Your Honor, do you mind if we could move the monitor from in front of the witness's face? The witness, I do, I mind. Mr. Howard, okay. Would you mind, Your Honor? The court, I don't mind. Is there a specific issue that you have, Mr. Glass? The witness, I do. Ms. Smith, Judge, can we approach sidebar? This is direct continued cross-examination by Mr. Howard. Good morning, Mr. Glass. Good morning, sir. Answer. No verbal response. Question. There was no response to this. Answer. No. Question. To your text on the first page. Answer. No. Question. On the second page, the state was discussing that essentially you were inquiring of Mr. Demons, Melly, what had gone on because you were trying to get information. Answer. Yeah. Question. And you see a conversation here where you get a response. I want to direct your attention to. Answer. I see it. Question. That statement. It says, I showed them niggas more love than they parents. Right? Do you see that? Answer. I do see it, bro. Question. Thank you. And the next statement by the next message in sequence is again from Melly. It says, TF. What does that mean? Answer. You tell me. Question. Okay. What does that mean? Answer. I don't know. Question. Okay. So you were having a conversation and you didn't understand the response? Answer. I don't know what TF means. Question. So you didn't understand that response, correct? Answer. I just said it. Question. Okay. Then there's another one that says, men, tell them fuck that if they think I did some shit like that. We can go to war. Nigga, you know I would never do nothing like that. Do you see that? Answer. Yes, I see it. Question. Okay, so state had mentioned that you got arrested recently and charged criminally, correct? Answer. Correct. Question. And on May 30th, not too long ago of this year. Answer. Yeah. Question. And one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that? Answer. I am now. Question. Pardon me? Answer. I am now. Question. So you got charged and you had no idea what you were charged with? Answer. Correct. And you are now on pretrial release? Answer. I bonded out, sir. Question. Okay. And while you're out on bond, you are of the opinion that if you don't come here, answer, I'll be in jail. That's the only reason. The court, excuse me, what happens is when they make objections, you wait before you answer. Objection overruled. The witness. Got you. Hold on just 1 second. I'm going to reread that portion. Okay, and while you were out on bond, you are of the opinion that if you don't come here, I'll be in jail. Ms. Smith, objection, Your Honor, relevance. The witness, that's the only reason. The court, excuse me. What happens is when they make objections, just wait before you answer. Objection noted, it's overruled, proceed. The witness, got you. By Mr. Howard, question. You're of the impression if you don't come here and sit in the chair and testify, you're going to go to jail. Answer, correct. Question. Okay, there are several instances in which Ms. Smith, the prosecutor, that questioned you, showed you a statement that you previously gave. Remember that? Answer, yes. And you told us you remember seeing me in the deposition not too long ago. Answer, I said what? Question, you remember seeing me last week on Friday? Answer, yeah, I remember. Question, and you recall at the time that your statement to the detective was a few days after the incident? Answer, you say, do I recall? Question, that's what your recollection was at the time? Answer, yes. Question, a couple of days after? Answer, a couple days after. Question, and now after seeing the statement, you realize that it was 4 months later, right? Answer, you say what? You said what? Question, the statement you gave to police. Answer, you're telling me it was 4 months, or asking me. Question, pardon me? Answer, are you telling me or asking me? Question, I'm asking you. Answer, that don't make sense. If you asking me, I told you it was there. It was 3 to 4 days after they died. Why are you asking me if it was 4 months if I just told you? Question, okay. So in a statement that you gave to police back then, you claimed that you had gone into the red vehicle in the rear seat, right? Answer, that was 5 years ago. To the best of my knowledge, that's what I said. Question, you're saying the statement was a few days after, right? Answer, what did, question, the statement that you gave to the police was a few days after the incident? Answer, yes. Question, and you said then that you had gone into the rear of the red vehicle? Answer, to the best of my knowledge, yes. Question, and then you watched this trial unfold on TV over the last couple of weeks, right? Answer, no. Question, you didn't watch any of this trial? Answer, I watched it, but I didn't watch it unfold or whatever you're trying to say. Question, okay. You watched this on TV, this trial? Answer, on the phone. Question, and you saw a video of yourself get into the red vehicle, right? Answer, correct. Question, and you learned that the statement that you gave a few days ago, a few days after the incident was gone? Let me reread that question. And you learned that the statement that you gave a few days after the incident was wrong? Answer, because I said I was in the back and I was in the front? Question, yes, exactly that. Answer, that piece? Question, yes, that piece. Answer, okay, yeah. Question, you forgot where you sat in the vehicle a few days after? You can answer. Answer. Answer what? Question. That question. Is that correct, sir? Answer. Did I forget? Question. Did you forget? Answer. I could have made a mistake and said I was in the back and remembered that I was in the front. Question. So when you told the law enforcement officers that you had gone into the back of the vehicle a few days after the incident? Answer. That's what I thought to the best of my knowledge. Question. That's what you thought? Okay. And when you got to Melly's house that morning, you had a key? Answer. Did you have a key? Question. No, I didn't. Did you? Answer. No, I didn't. Question. Who had a key? Answer. I don't know. Question. Do you know of anybody having a key to Melly's house? Answer. I don't know. Question. Okay. But you did gain entrance to the house that morning after you left the studio? Answer, yeah. Question, and then you said you just went and crashed and went to sleep in Judy's room, right? Answer, factual. Question, and you were awakened by your friend Drew? Answer, I did not say that. Question, were you awakened by your friend Drew? Answer, I said I was awakened by phone calls. Question, did you ever make a statement differently where you claimed that you were awakened by Drew? Do you understand the question, sir? Answer, I don't even remember getting asked a question. The court, all right, restate your question. Question, did you ever make a statement to the police? Answer, I don't recall. Question, okay, do you recall now being asked this question and giving this answer? Question by the detective. Then, and so when you first saw Drew, when did you see him? Where did you see him at? Your house or Frida's house? Answer, at the house in Miramar, at Melly's house. Okay, he woke me up. It was like, come to the hospital. You said that? Answer, I don't recall. Question, don't recall? All right. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right? Answer, plenty of phone calls, different people. Question, pardon me? Answer, different people. Question, different people. And the one that you answered was Ricky. So you were awakened by a phone call from Ricky. Answer, to the best of my knowledge. Question, so as you recall it today, Ricky is the one that woke you up with phone calls and not Drew that woke you up in person. Answer, correct. Question, okay. So you smoke a lot of marijuana, right? Answer, possibly. Question, you smoke it anytime you get a chance, I think is how you phrased it. Answer, it's your answer, yeah. Question, that was your answer. Answer, I smoke when I smoke. Question, you smoke when you smoke? Answer, yeah. Question, and when's that? Answer, when I smoke. Question, and when would that be? Answer, when I smoke. Question, how many times a day? Answer, twice, 3 times maybe. Question, and on the night in question, before you got to the studio, on the day in question, you had smoked at least 2 joints, right? Answer, that's your guess. Question, that's what you said, right? Answer, I don't recall. Question, okay, and when you got to the studio, you were smoking, correct? Answer, possibly. Question, were you or weren't you? Answer, that was 5 years ago. Question, you forgot? Answer, I don't recall. Question, and you were drinking Hennessy, I believe, or do you not recall that either? Answer, it's possible. Question, possible, but you don't recall. Answer, I don't. Question, okay, so you don't recall much from that night then, do you? Right? Fair? Answer, right. Question, and when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio, right? Answer, yeah. Question, and you didn't wake up until you got to the guard gate? Answer, I woke up when we came to a stop. Question, you did not wake up until you got to the guard gate. Am I right or wrong? Answer, I woke up when we came to a stop. It was at the guard gate, yes. Question, have you ever seen track with a gun? Answer, it's possible. Yes, maybe so. Question, okay, so you don't know of any friction between Melly and Anthony Davis at any time? Anthony Williams at any time? Answer, not that I know of. Question, and you don't know of any friction between Melly and Christopher Thomas at any time? Answer, not that I know of. Question, you didn't see any friction at the studio that night of any kind, did you? Answer, I didn't. Question, you did? Answer, I didn't. Question, with respect to your daily marijuana regimen, did you smoke before you came here today? Answer, I did not. Okay, I have nothing further, Judge, thank you. The witness, I should have. The court, counsel, is there any redirect, Ms. Smith? Briefly, your Judge. Briefly, Your Honor. Redirect examination by Ms. Smith. Question, Mr. Glass, did you live in Broward County back in October of 2018? Answer, I did not live here. Question, okay, when did you come in relation to this incident in Broward County? Answer, I was picked up probably, I don't know, I was picked up on the weekend or something like that. Question, so how would you, I guess, date how long you were here prior to the incident, time frame? Answer, 3 days, 2 days. Question, okay, so you were not a full-time resident of Melly's residence? Answer, I was not. Ms. Smith, nothing further.
My bad. I've been busy, but
yes, Your Honor.
Pretty soon we shut the lab up. I gotta go to work and shit, man. You know what I'm saying? I'ma stay watching.
That concludes the readback of the witness covering Glass's testimony, so you may now retire and continue with your deliberations. Thank you, ladies and gentlemen. Thank you. Let the record reflect the jury stepped out. Counsel remain on the defendant. Counsel, I have another question that the jury posed when they came in for readback, and the question reads, what is the conversion to 1 meter equals how many feet?
Rely upon the testimony. Rely upon the testimony.
Everybody agrees? Can I do that just in writing here? Is that all right with everybody?
That's fine.
Play Diablo 4 on Xbox Series X.
The time of prophecy has come, knights.
Hell is coming, brother. If we can't stop Lilith, we'll all be damned.
As a YouTuber, vidIQ is one of the most powerful tools that I use. I spend a lot of time shooting and editing, so I want to make sure that each video I make is putting its best foot forward. That's where vidIQ comes in. I don't know a ton about SEO or the algorithm, and thankfully using this tool, I don't have to. From recommended tags and keyword research to trend alerts and channel audits, vidIQ has become a massive part of my content strategy. Now I always know the best time to post, and I can see how my channel is performing against the competition. I've tried out other tools that are out there, but I've found that vidIQ is the easiest to use, the quickest to set up, and the most effective. Now I spend less time optimizing and more time creating. Get your first 30 days of vidIQ Boost for free at vidiq.com/creative.
The readback of Travion Glass's testimony is now complete, so the jury has heard it all. We are going to start taking your questions now, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Twitch, TikTok, and Threads, and we'll get to as many of them as we can. Michael Bryant, host here at Law and Crime and also an attorney, is here with me. Offie Patterson is an attorney here with me as well, and Mina Lona, a SiriusXM host, is here. Thanks everybody for being with us today. So let's get to our first question. Smurf Duh Gemini from Twitter, Michael, why did the phone say mobile the whole time? And we know that we had to stop at red lights.
Why did the phone say, oh, as if it was moving? Is that their question?
Yeah, Melly's phone said mobile the entire time they were driving, and then it says outside stationary when you exit the vehicle, according to the prosecution.
Yeah, I'm guessing that the technology, as you know, I'm not a big fan of it, but I'm guessing that it requires a certain period of time actually motionless before it registers as something other than mobile. That'd be my best guess.
All right. Let's get to this next question. This is for you, Offie. This is from @JustChillin' and we've heard from @JustChillin' quite a few times from Twitter. Do the defense attorneys in this panel think that the defense picked a good strategy with taking Melly out of the crime scene, or do they think there could have been a better strategy?
So I think they had to choose. So I think they wanted to rely on their alibi witness. And their alibi witness said he wasn't there. They said he was at the house at the time of the murder. And I also think that they didn't have to get a crime scene reconstruction expert, and it saves them having to just add explanations because we knew Melly was likely not going to testify. And putting him there would have required a lot of explaining and a lot of testimony. And you wouldn't want to open Melly up to too many questions if he was going to testify. But I think it wasn't necessarily the best strategy at the end of the day, because the 9807 number, I do believe, was sufficiently tied to Melly. We believe it was his. And I think that if you follow the phone, you follow and you find out and you learn how the murder took place. So I don't know if it's going to work out, but they use that strategy because of their alibi witness.
Mina, I'll send this next question to you, and it's about Travion Glass. The testimony we just heard read back by the clerk for the jury, and he was with everybody at the recording studio that night. So Cindy Hedden asks from Twitter, I just answered part of the question for you, Mina, but who is Travion Glass? I haven't been able to watch much of this trial.
Travion Glass is a childhood friend of Juvie. They've known each other for over a decade. He was in that red Mitsubishi, which is the other car that was leaving the studio the night in question. He was staying at the house as well, Melly's house. So he has a lot of ties to not only the people who have passed away, but also Melly and this YNW collective. So he was one of two people that were actually in the red car that testified and gave their account. So basically friends of the people who were affected, and they were there so they can give us their opinion on or their recollection of what they remember seeing.
Michael, this next question is from you. It comes from @Reba05 from Twitter. As legal experts, do the questions asked by the jury lead you to determine which way the jury is leaning?
You know, it's always tempting to put probably more into the questions than is the reality. But of course, you want to use that as any sort of insight as to which way they're going. Hopefully, you interpret it as something that helps your side, but that isn't always the case, and sometimes it's totally irrelevant. In this case today, we already know they wanted to get a statement made by Bortland Henry at the hospital, and then they changed their mind and said, "No, we don't want that." So what does that tell you? Does that tell you that they've decided amongst themselves that the statement means nothing? And we believe it's the statement in which he first said, hey, this all happened as a result of a drive-by. Does it mean that they believed his statement, don't need to hear it again, or they don't believe it and they don't need to hear it again? So the short answer is you just never know, but you try to interpret it as best you can for your side.
Alrighty. Well, we're going to sign Offie off. So, Offie, thanks for being with us today. We really appreciate it. And we're going to take a quick break. When we come back, we are going to have Terry Austin come on and tell us what happened in that courtroom and take more of your questions. So stay with us. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back.
Grocery outlet, bargain market.
Excuse me, are these the Independents from Hunger food bags?
Yes, they sure are.
My friend said last summer her family bought bags to help kids in her neighborhood.
That's right. The money and food donated through Independents from Hunger stays right here in our town.
I saved up all year. Can you tell me how many bags I can buy with this?
Absolutely.
Grocery outlet, bargain market.
I wanna feel a rush, tell them turn the pressure up. I be setting fires for the thrill, I can't get enough. Knocked down, never knocked out. When I'm in the clutch, leaving limits crushed. Gotta get it, ain't no giving up. Nah, got the whole world waiting on my fall. Me against the odds, bet it all. Better stack a tall, non-stop, fighting non-stop. I've been through it all. Eyes locked, coming in hot, breaking through my walls, yeah. Try to count me out, but I'm on the grind, yeah. Count down till I'm going live, yeah. Feeling like a fire on the inside. Roll from the ashes to survive. I'm coming alive. As far as I'm concerned, dog, I never have to check it. Me, myself, and I got bigger plans, you might have guessed it. This is my world from sea to sky, didn't plan it. Evil combated, people will try to test your patience. Keep my back from the reaper who's hunting the running, you gotta decide. I'm just controlling my fate. I'm just controlling my fate. Oh, I'm just controlling my. I'm just controlling my. I'm just controlling my. It's not the same, so it's time to rise. I feel my soul coming alive. Coming alive. Roll from the ashes to survive. I'm coming alive. Here we go now. Here we go now. Yeah, yeah. Here we go now. Here we go now. Yeah, yeah. Here we go now. Come on, come on. Roll from the ashes to survive. I'm coming alive. I'm coming alive. I'm controlling my fate. I'm coming alive. I'm coming alive. Just controlling my fate. I'm coming alive.
Welcome back. I'm Anjanette Levy, and thanks for being with us here on Law and Crime as we take your questions in the YNW Melly double murder trial. There was a readback of testimony requested by this jury. They are now deliberating yet again the fate of YNW Melly. Let's bring in our panel, including Terry Austin of Law and Crime. Terry is down there at the Broward County Courthouse. Terry, bring us up to speed about this readback and what was going on in the courtroom as it was happening.
Well, first of all, we heard a question from that jury. It was the first question, and they asked about the call logs for 9807, and then they also asked about witness testimony, which you just mentioned, Anjanette. We heard some of that, and they were asking for Trevion Glass to be read back, and also Michael, and we remember him, it's Michael Kelly. He's the one who was the crime scene investigator. He talked about trajectories, and they also asked for someone called, Cortland, but they got the last name wrong. They said Sutherland. That was corrected later, and it was Cortland Henry. Then they said they didn't need that testimony because it was the investigation. They wanted to hear a little bit more about what he said, but they decided, no, we don't need that. So ultimately, the bottom line was the judge said, look, we can read to you what the testimony was as far as Trevion Glass is concerned. It will take a little bit longer for the court reporter to pull together the testimony of Michael Kelly, and so she's working on that. But we did hear her read the entire testimony, and frankly, a lot of it was, I don't know, I don't recall, and I don't think this is going to refresh my recollection. We mentioned this before, and I'll just end with this. I do think the parts of his testimony that the jury wanted to hear was who was in that car and whether or not what Melly was wearing was the same as the beginning of the night. And so it's really going to be up to the jury to determine whether or not he is credible. And I will say that part of the defense did read when they were doing their cross-examination about why he was there, and he was subject to charges if he didn't come and testify. So that jury is going to have to determine whether to believe his testimony over what they've seen from the defense side.
There was also some testimony. I guess they asked him if, it would refresh his recollection to see his prior statement about whether or not Melly left and came back at some point that day. Was that right, Terry?
That's right. And he said, no, it's not going to refresh my recollection. So from an evidentiary standpoint, if the witness says it's not going to refresh their recollection, then it doesn't get to be read in, and it wasn't read in, and he didn't say anything more about that particular issue.
All right, just briefly, Terry, we've got the first question coming out to you, the first question of this block. This is from Tracy Dye 00437-887 from Twitter. Who was escorted out of the courtroom today during the jury questions, if you know?
Yes, I actually saw that. It was packed this morning on both sides of the courtroom, and on the victim side of the courtroom, they get an entire side reserved for them, of course. And there was a phone that went off, and when that happens, the court personnel is very strict about that. Those Broward County officers will take a look at where that ring came from, and immediately the person is escorted out. There's no conversation. They get a point towards them, and then they sort of get a finger out, and they're escorted out. And frankly, I've seen them say, you're not coming back. And so we'll see what happens. I'll look to see if that person comes back. But yes, it was one of the individuals who was sitting in the audience today who got escorted out for her phone.
Very interesting. All right, let's get to more questions. And this next one goes to Michael Bryant. Michael Jorgensen from YouTube, who is a frequent question asker here. Does the longer the deliberations go lean more and more toward a hung jury? Do the questions give you any indication of what the jury is starting to think?
Yeah, I think in general, if we can generalize here, longer could mean they're hung up on something. In this case, where are we now? 5 hours, a little more than that, not counting the readback period. That's not long enough to really get to that point. Maybe, if we're having this conversation Monday or Tuesday, maybe. And it really depends on whether it's a big split. Is it one person they're trying to, put in a headlock and change their mind? You just don't know at this point. And what we've heard, as I mentioned before, and Terry just mentioned, that statement given by Bortland to the police was first a concern and then not. And now we know that the Trevion Glass testimony in its entirety was important. I think if we hear them ask for Adrian Davis to read back his testimony, that may be enlightening. To me, that would totally laser focus their concern, or somebody's concern, one of them, 11 of them, on this whole alibi. And was it believable that Melly was not in the car when the shooting took place, that Melly was back home just sleeping away, and he got the bad news right along with everybody else. That would be critical to me.
Mm-hmm. So this one, Mina, I'll send over to you. It is from Ron Janae. I'm hoping I got that one right from YouTube. Do you guys think that the jury is confused because they asked to restate someone who didn't even testify?
I think it is and can be confusing. There are a lot of names and a lot of moving pieces. And then I think the other confusing part is also their government names versus their street names. You know, Jameson Francois versus Track. I think that can be all very hard to keep up with if you're not writing it down. I mean, even in my notes, I made little, you know, I have all these graphs and things going on just to keep track of all the moving pieces. And it does become confusing. And it's very evident from them even getting Cortland Henry's name wrong, which is literally a co-defendant. So he's one of the main names, the main people that are also involved in being accused of this murder, and they can't even recall his name. So I can see them being very confused in there, and I wouldn't be surprised if they continue to ask for more of the testimony from other witnesses. And also, we have to mention the prosecution had 27 witnesses. So to remember all the members of YNW and then their adjacent friends like Fredo Bang, and then also all the 27 people that the prosecution put on the stand, it can be a lot for a jury.
It is a lot, and there are a lot of names. So I could totally see them getting the last name, you know, Cortland Sutherland versus Cortland Henry mixed up. Terry, you know, that brought a question to my mind. Were any of these jurors, or I don't even know, were they allowed to take notes at all? And if so, did some of them take notes?
Yes, they were allowed, Anjanette, and yes, some of them did take notes. Not many, though. You can't really see below the rail, but I know for a fact because they're leaving their notes down. I would say probably 4 of them are taking notes at this point, and perhaps they didn't catch the name. I mean, Mina is absolutely positively correct. If you don't have that list written down and you don't have the alternate names written down that each of them has, I think it's very hard to follow. And so I think altogether, all of them deliberating may not have had that full name. And remember, his name is Cortland and Bortland and, you know, Henry. So he's got multiple names. And so it may have been difficult for the jury to remember.
And just speaking from personal experience, I found myself going back to the testimony. I found myself going back to a lot of the testimony and re-listening, and they don't have that advantage. So I can see them being very confused by just listening to the testimony once.
Yeah, I always do that too. Like at night, I'll go back sometimes and listen to it again. I just make sure I didn't miss anything and that I heard everything right. So they do not have that advantage, and it's tough. Our next question comes from Facebook. Michael Asti Bryce asks, I have 2 questions. So we've got a twofer for you, Michael Bryant. If the defendant is found guilty, what charges would Cortland Henry face? And secondly, do lawyers get paid extra for a win in court?
That's interesting. You know, I guess, let me answer the second question first. It kind of depends, because in civil cases, a lot of cases are contingent, and a win generally means you're going to get a bigger share of money from the win. Criminal cases, you know, not so much. You may get more hourly fees as a result of some work that you've done. And a lot of folks who are paid hourly charge a certain amount up to trial, and then at trial, the fee goes up, the hourly rate goes up. But it's not necessarily tied to a win or a loss. You can still pay the same amount if you lose. What was the first part of the question? It was, the charges that Cortland might face. Well, we know he's now basically looked at as an accessory after the fact, although I think he is also charged with the first-degree murder. It's almost under a felony murder analysis there, because there were murders that took place while he was in the car. I don't think they're going to put the gun in his hand. So the biggest claim against him, and it relates to that hospital statement the jury was waffling about whether they wanted to see or not, is what part he might have played in any cover-up. If the drive-by shooting was just a cover-up, what did he have to do with that? I think his concern, if the jury, especially if they convict Melly, his concern is going to be as an accessory after the fact. If they acquit Melly, that may change the dynamic a little bit. It'll be interesting to see what, if any, other charges might be leveled against him. It'll be very interesting.
I'm going to take this next question because I can do it really quickly. So from YouTube, Team Pretty 20 asks, how much time is he looking at for manslaughter? If he is convicted of manslaughter, that lesser included offense, it's a maximum penalty of 15 years in prison, and then I believe something like a $10,000 fine. So we'll knock that one off the list. Nicalia Lancaster from YouTube, Mina, asks, what would be the reasoning for them wanting to hear Mr. Glass's testimony?
It was very crucial. I mean, this is where we found out that Melly was at Fredo's house after the alleged murder. This is where we found out that Melly had a change of clothes and he had shorts on. It was very crucial and important. And it was also our first time hearing from someone that was actually there the day of the crime. He was in the studio they were all in. He could testify and speak to the fact that there was no conflict in the studio. That was actually a question that I had. What happened in the studio? Did anything happen in the studio that led to some kind of conflict that could have resulted in these two young gentlemen being murdered? I wanted to know that, and he provided those answers. He said there was no conflict in the studio. People were sleeping. That's why we left. This is also the first time that we find out that it's a 12-hour prepaid studio session, which to me is very important, because to me it says Melly went into that studio that day to be there for 12 hours. So now I'm questioning, was this premeditated? Because it was a prepaid 12-hour studio. So his testimony was very crucial, and it allows us to go to that day and go in that studio and see what happened and see how Travion Glass recalled Melly's movements even after the alleged murder.
All right, keep the questions coming to us, and we'll take more of them when we come back. Throw them to us on YouTube, Instagram, Twitter, Threads, and TikTok, and Facebook, and we'll get to them when we get back. I'm Anjanette Levy. You're watching Law and Crime.
When I built this business, we didn't have payment solutions like Melio.
Paying business bills with Melio means you get to choose the payment method that works best for you. So you can pay vendors with your credit card, even if they only accept checks. This means you can hold on to cash longer and maximize rewards like miles, points, and cash back. Sign up for Melio now.
Be like a boss.
Upgrade your vocal mix from this.
How can we keep in touch?
To this.
How can we keep in touch if I can't even touch you?
Experience the latest vocal enhancing technology for yourself at the click of a button. You no longer have to spend hours trying to make your vocals sound professional. I've already done it for you with Rise Up Audio vocal presets. Start saving thousands of dollars by avoiding sound engineer fees, studio time, and expensive plugins by letting the presets do the work for you. Inspired by today's top artists, these presets will have you sounding radio ready in seconds. And the best part, our presets use plugins you already have, so there's no need to download new software. Download one for yourself now at riseupaudio.com.
Welcome back, and thanks for being with us here on Law and Crime as we take your questions in the YNW Melly double murder trial. That jury in the case is deliberating now. They're back in the room discussing whether or not the state proved its case on the first-degree murder charges. There's a lesser-included offense the jury is allowed to consider as well. That's a manslaughter count that was added yesterday as they heard closing arguments, or before the closing arguments, I should say. So we are taking your questions. The jury finished listening to a readback of Travion Glass's testimony just a short time ago. So let's get to more of your questions and keep them coming in to us as we await that verdict. This one is for you, Terry Austin. Jamer Lee from Instagram asks, why don't jurors have access to video of testimony while deliberating? It seems out of touch to have to listen to a readback.
That is such an excellent question. And in fact, the issue came up today. The jury wanted the testimony read back, and the defense actually argued that it shouldn't be read back, that they should watch the video because this is being live streamed by us. So it could be absolutely played back. But the state said, look, the jury instruction says that it should be read back, and that's what we normally do traditionally. And we looked at that jury instruction, and in fact, defense David Howard said, Judge, I'm reading the jury instruction and it says playback or read back. So the jury instruction is actually ready to go for modern day, and this is the best evidence. At the end of the day, Judge Murphy said, look, we're doing the standard charge. I'm not going to have them look at the video. It's not something that has been admitted into evidence, so they're just going to have it read back to them. And the judge actually said he looks at the word playback in that jury instruction to just mean playback any video evidence from the trial, not playing it back from a live stream. So at the end of the day, even though we have that modern technology, the judge just only allowed the reading back of that testimony by the court reporter.
You know, Michael Bryant, that makes sense to me because that's not how the jury first viewed that evidence. I can see, yes, we'll play back an interview, a police interview, or we'll play back a surveillance tape or whatever. But these viewers watched for themselves in the flesh Travion Glass testify. They didn't watch it on television. So do you think that was the right decision, or do you think they should just be queuing up the testimony from the Law and Crime feed?
I'm always big on the visual. I think they're going to get more out of it than they do a static readback. But here's the way I would argue it. If the testimony they want favors my guy, I want to see it. If the testimony they want doesn't favor my guy, then I say read it, because it's a lot less effective.
All righty. Let's get to our next question. Cynthia Dawson from Facebook. Michael, I'll throw this one over to you since I inserted one of my questions. Why did only one person out of a full car decide to testify that Melly got in? I can add to that too, but what are your thoughts on that,
Well,
Michael?
I think we know that it wasn't for lack of some effort. They were trying to get a hold of everybody that was there that night. And the question really is how hard they tried, because a lot of folks evaded their efforts, however those efforts might have been. So that's why we only heard from two, and there could have been probably 3 or 4 others that were there that night. Police were not successful in corralling them or encouraging them to testify.
We do know that Jacoby Mills and Dontavius Withers, who were the other 2 people in that vehicle, I just want to add to this, were interviewed by law enforcement. Dontavius Withers, for his part, gave a couple of different stories about whether or not Melly was in the vehicle or not. So he certainly gave inconsistent statements on that point. Jacoby Mills was interviewed at one point in time, gave a statement to law enforcement. So why he testified or didn't, we don't know, but he said some things that were pretty incriminating to Melly. So there you have it. Our next question comes from Trez Anthony. I have a question. Did Glass also testify, Mina, and say that Melly had on shorts after the studio session?
He did. And that was that bombshell. It was the headline everywhere. All the hip hop blogs. Melly had a change of clothes. It was a big revelation, and he did testify. And now it really just comes down to, can you piece everything together? I think I heard Linda say this. You know, if Melly was home just throwing it out there because that's what Adrian Davis said. He might have changed into shorts. You know, I know when I go home, I call it outside clothes, right? If I'm wearing it outside, I don't want to wear it inside the house. So I change every time I go home. I just don't want to wear my outside clothes inside the house. So there's been some conversation regarding if him wearing shorts means anything. But that was a big deal in this case, that not only did Cortland have a change of clothes, but also Melly.
Both wearing different clothes, according to the testimony in this case. And we have video evidence in Cortland's case, you know, Cortland Henry's case. Swag Sternot, I hope I got that right, Swag Sternot from Instagram. It asks, is it common, Terry Austin, to get a guilty verdict without the murder weapon?
I would say it's fairly common. I think most people believe you have to have that quote unquote smoking gun. And in a circumstantial case, I think most people think it's very hard to find someone guilty. But jurors, they are very smart. They piece together, they use their logic, and they figure out what actually happened if you have enough corroborating evidence. So the point being, if you have those shell casings, if you have the trajectories, if you have all of the information from the phones putting everyone in the same place at the same time, if you have cameras where you can piece it together, if you don't have a gun and you have all of that other information in a case like that, I do think the jury could come to a conclusion that there is a guilty verdict. But we'll have to see if there's enough evidence here for the jury to come to that sort of conclusion. What I will say, it is much more difficult when you don't have that weapon. So it's going to be hard for this jury.
We shall see. These knee, I think I got that right on Instagram, Michael Bryant. Can he be found guilty of killing one of them but not the other one? Or if he gets found guilty, will he be responsible for both?
Yeah, it's very interesting, and it crosses over into the felony murder issue that we've talked about early on, and where the judge decided that was inappropriate because we couldn't determine which person died first. Bizarre analysis, in my opinion. But having said that, in theory, yeah, he could be found guilty of one without the other, but that defies logic. I mean, how would that exactly happen? I mean, talk about holes in the fact pattern. Now we got tons of them, because there's just no suggestion that there was a second shooter, or that somehow the drive-by maybe killed one and not the other. But technically, yeah, they could find he is responsible for one of the deaths and not the other. That would be bizarre.
Let's get to some TikTok questions now. This one's for you, Mina, and I hope that you've done your studying on the cell phone data. So if not, that's fine too. But that was a lot of information to process. It comes from Trey Joseph 23 from TikTok. Couldn't the phone have been given back to Melly when Bortland met back with them at Fredo's?
My bad,
I mean,
y'all.
anything
I'm
could have
sorry, it's been a
happened.
crazy
We
day.
just don't know
I'm gonna
what
log
happened.
off and shit. You feel
You know,
me?
the phone is a big contention here. Who had the phone?
I'm gonna try to live
Where
stream
was
when
the
I get,
phone? Was it
get off work
outside?
tomorrow,
Was it in
'cause I have to
Melly's
go in at
house?
7
Was
right
it at
away,
Fredo
some crazy
Bang's
shit.
house?
I'll see y'all.
I think that's the problem with this case. We don't know for sure, and everyone has a different interpretation of the phone